Hi, who are
Here.
I'm expecting more.
And I'm expecting Mark. Whoever just signed on as iPhone, could you let me know your name and the case you're here for?
Nick DeShane versus Auburn Housing?
Right, I see you, Mr. Shane. There's somebody else who has logged on and their log on only says iPhone.
It's easy.
Oh, it's
on Having the what you're top having.
Two. It's just great.
Sounds good to me.
P7 what I'm having. Oh, yeah. Well, someone that I was gonna say keep small. I'm that great. I got it now. Like a pita bread.
Yeah.
Oh, this is easy. Well.
We trust you.
Okay. Miss Lorraine, is that you, Miss Lorraine? Is that your audio? If anyone's talking, I can't hear them. Well, I think it's because so one of them is muted.
Oh, no kidding. Huh. Well, I've been without HRC. I've been for a couple.
Yeah, we're working on that, and I apologize about that. It's a surprisingly difficult challenge for a lot of different reasons. Okay, so that's this. Okay, so that's her audio. It's 8:31. So we can start the business session.
Okay, everyone can hear me all right? Good morning, I'm Jeff Ashby, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device like a cell phone or a pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda. Is it true they're available in the back of the room?
They are available.
They've also been provided electronically to you folks who are online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. For our first order of business, we'll need to adopt the agenda and the consent agenda that's been provided to my fellow commissioners. I'll entertain a motion.
So move.
Second.
So just for folks who are watching online, when we are having people participate remotely, we are required to use our remote participation protocols, which requires that for every single motion that is made, every commissioner must be able to be seen and heard on screen for their votes. So I will, for every single motion, poll commissioners one by one in order of seniority. So the motion is to adopt the agenda and consent agenda. If you agree, we will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes.
Next are the minutes. A motion to adopt the minutes of our December 2022 commission meeting.
And that was, I'm sorry, that should say January 2023.
Oh.
That is
Okay.
so
Then,
it should be
since we did that already, let's do the January 2022 commission meeting minutes.
January 2023.
23 even. Since we did that already.
It's just going to be that. Maybe we should start again.
All right. I'll entertain a motion to adopt the minutes of our January 2023 commission meeting.
So moved. So it's been moved and seconded. Is there any discussion? Forgot to ask the last time. Seeing none, the motion is to adopt the minutes of the January 2023 commission meeting. If you agree, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Motion passes.
Director's report.
Yes, you have for administration, You have a memo from me regarding personnel, an update in there. In compliance with status of pending reasonable grounds cases. You have a memo that purports to be from me, but was actually written by Dave Riley. And it says the status of pending cases, there were 0 cases successfully conciliated since the last meeting. There were also 0 cases unsuccessfully conciliated since the last meeting. There are 8 cases in progress. Good morning, Commissioner. For agreements, there are no new conciliation agreements for you to approve, but I do have, and I think you received memos about 2 conciliated cases in which we are ready to dismiss the cases completely because the conciliation agreements were fully implemented. So there are 2, and you can take them together, separately or together, either way is fine. The 2 cases are hold on,
20-0524.
well, nope, there's H 190397. Italy versus Augusta et al. And H 200524 Johnson versus Auger.
Right.
So I would ask that the commissioners make a motion to dismiss those cases.
I'll move that we dismiss H 190397 Bailey versus Avesta and E-0524 Johnson versus Auger for the reasons that compliance and the public interest have been had and have been privately settled.
Second.
So it's been moved to dismiss both successfully conciliated cases. H 190397 and H 200524. It's been seconded. So any discussion? Seeing none, I will ask each commissioner in turn if you are in favor of the motion. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
And Commissioner Douglas, I think you joined us after I started that. So I don't know if you heard all that or if you would like to abstain from that.
Yeah, good morning, everybody. I missed most of it, so I'm going to abstain.
Okay. So with that, we have 5 commissioners here. Oh, sorry, I'm keeping going. Sorry, I got lost track of myself for a minute. For investigation, we received 35 new complaints in January. I administratively dismissed 5 complaints in January, and for predetermination settlements, there were 9 of them in January with benefits of over $338,000 to complainants. For litigation, I would ask that we take that after executive session, which brings us to new business. There's not much. I did want to let you know that the legislature has started hearings on both the supplemental budget for this fiscal year and also the upcoming biennial budget. There's nothing for our agency in the supplemental budget, but there are a number of initiatives that the governor included in the biennial budget proposal for our agency, which is fantastic news. It's by far the greatest amount of new resources that have been proposed for our agency since I've been here. We're extremely grateful. There are 2 new positions included, one for an investigator and one for a business manager, which will be a huge help as we process payments. It's mostly payments and all of the work that goes with them, largely for our mediation program, but also for FOIA requests. There's also a number of other sort of housekeeping initiatives, including getting commissioners connected to the Office of Information Technology for support and licenses for you to have OneDrive through the state. Previously, we've been doing things on our own, but we are coming under the OIT wing. So there's overall, I believe there are 10 initiatives. Some of them are very small, including things like commissioners' mileage for coming to these meetings. But it's for us a huge investment of resources, and we're incredibly grateful. I think our agency will present the initial introduction of our budget initiatives in a few weeks to the appropriations and judiciary committees, and then there are several more hearings after that. So I'll keep you posted as we go. That's about all I wanted to mention for new initiatives. So I think we have about 6 minutes. Yep, before we begin our case hearing agenda. Commissioner, do you want to keep us in adjournment till then?
Oh, I didn't know it was up to me. I would keep us in adjournment of it. If we're back at my office, that's what we do. Until 8:45, please.
Thank you.
Oh, no, you're gonna sit mute. You ready?
Yes.
All right. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that an unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written material will be accepted today. Excuse me. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I'll ask that you introduce yourself as you come to the podium.
And
Thank you. It is on the back side of this.
as a reminder to folks, not to use the names of third parties or witnesses. We have given them pseudonyms in the reports. As you call the first case, period.
All right, I am going to call the first case, but then I'm going to recuse myself. The first case is MHRC number ED, PA 20-0470. That's Cassavant and the University of Maine system, and I do have a conflict, and so sit this one out.
So, since this is a reasonable grounds case, we'll hear from respondent first.
Good morning, commissioners. Deirdre Salsik, representing the University of Maine system. I'm joined remotely this morning by Gretchen Catlin, who's the General Services Officer and Risk Manager for the University of Maine system, and appeared during the Issues and Resolutions Conference held in this matter. This case arises out of an optional student health insurance plan offered by the University of Maine system during the 2019-2020 and 2020-21 academic years. As we stated in our September 30th submission, the investigation in this matter took quite a while to get going. Ms. Cassavant filed her complaint alleging discrimination on the grounds of transgender status and or sex on October 28th, 2020. It wasn't until February 11th, 2022, 18 months later, that the MHRC contacted the university for any information whatsoever pertaining to this case. And in fact, the record demonstrates that MHRC accepted information and supplementary filings by the complainant in that 18 months between the filing of the complaint and the time that respondent was actually contacted about this matter. By that point, Ms. Cassavant had appealed the insurance company's findings directly. She had also filed a complaint with the State of Maine Bureau of Insurance. Notably, the university was not notified at the time of any of these appeals. And I think that that's very relevant in this matter because central to this case is the fact that the conduct complained of by Ms. Cassavant was actually committed by the insurance company, which has no legal or corporate affiliation with the University of Maine system, nor is it an agent of the University of Maine system in any way. And it is crucial to establish the fact that the insurance company denied coverage of the medical procedures at issue in this matter, not the University of Maine system. University of Maine system is not an insurance company and should not be held liable for the actions of a corporate third party with which it has no legal affiliation. We respectfully request that the commission credit the record evidence and findings of University of Maine System Equal Opportunity Investigator Angela Tisson. In her report, she stated that Ms. Cassavant was not required to enroll in the SHIP, that's the Student Health Insurance Program, as a condition of her access to any university program or activity. Ms. Cassavant was not treated differently or otherwise discriminated against by the University of Maine System. Moreover, the law that's cited in the investigation report, which is an act to protect healthcare coverage for Maine families, signed into law by Governor Mills on or about March 19th, 2019, regulates insurance companies, not universities or employers or any other entity that may offer a health insurance plan to, in this case, students or employees in an employer context. The university did not require Ms. Cassavant or any other student to enroll in the student health insurance plan. For the 2019-2020 school year, UMS did require proof of health insurance coverage under a plan of the student's choice. And it's important to note that the Affordable Care Act of 2010 allows dependent children aged 26 and under to enroll in their parents' health care plan if they so choose. During the Issues and Resolutions Conference, Ms. Cassavant's mother, Susan Cassavant, disclosed that the health insurance plan that she and her spouse subscribed to did not cover gender-affirming health care. Moreover, Ms. Cassavant had her choice of healthcare coverage through the state of Maine's healthcare exchange. In the last few years, the state of Maine has expanded access to Maine Care and Medicaid, and folks are eligible to enroll in a health insurance plan of their choosing, one that fits their needs, by going onto that website and entering income information and other relevant information that would help them to determine a health insurance plan that would best meet their needs. Ms. Cassavant has not established that the student health insurance plan was her only option for healthcare coverage during the time period relevant in this matter. The real issue at hand in this case is an insurance company's initial denial of coverage for certain medical procedures. The University of Maine System, again, is not an insurance company. We had no role in approving or denying any of the medical procedures that Ms. Cassavant sought as part of her gender-affirming healthcare. And the university is not responsible for the actions of an unaffiliated insurance company. Furthermore, by offering an optional insurance plan, the university did not engage in any discriminatory conduct. This plan was offered to all students within the University of Maine System. We serve nearly 30,000 students per academic year. And again, because of the myriad options now available to students, anyone who may not be employed full-time or have access to health insurance through a traditional means, there are multiple options out there on the marketplace, and each person can decide for themselves what best meets their needs. The university respectfully requests that the commission overturn the reasonable grounds finding as to the University of Maine System in this matter. Thank you.
Thank you. Any commissioner questions for Attorney Salsic? Did I pronounce that wrong again?
Salsic, no problem.
Okay.
Happens all the time.
I'm sorry, what is the name?
Salsic.
Salsic,
Salsic?
yes.
Any commissioner questions for respondents council? Commissioner David?
Yeah, you require that the student have a health insurance plan. You offer the SHIP that you offer to them, correct? What is the cost of that? Is it not of extremely low cost insurance?
The cost is, again, it's an amount that we are able to obtain because of the size of our student body. We use a broker. I can tell you that in recent years, the number of students that have enrolled in the health insurance program has decreased. And some of that is due to, of course, the many options out there on the marketplace. It's also, it's not, we are not required to offer a health insurance plan by law. It is something that we offer to our students, knowing that some students may be coming in from out of state. Some health insurance plans don't offer out of state coverage. So
You
the
require
price
that they have insurance, that they either have that SHIP plan that you offer them, or they produce proof of another insurance. So you require that they have insurance.
during the 2019-2020 school year, we did require proof, some verification of enrollment in a health insurance program. It didn't have to be the SHIP.
And that SHIP program you negotiated with the company, correct?
Through a broker. We did not engage directly with the insurance company, but yes, we use a broker to.
Well, you can't engage directly with the broker and said what your requirements were. And it was important to you, it says in the record, that you negotiated a plan that covered your health centers, that had unlimited coverage for athletic injuries, had these bells and whistles unique to a university campus setting. Isn't that a fair statement?
We also researched options that would cover preventive care and primary care for our students.
But you didn't research options that covered gender affirming care. That's the point.
Respectfully, Commissioner, the health insurance system is such that there are myriad plans out there available. And given the population that we have, young people who most of them do not have full-time jobs that will allow them access to a health insurance program.
Right.
Our concern was to offer a health insurance plan that would cover primary care and emergency services. This is not a catastrophic health insurance program. And again, it was optional. There was no requirement that students enroll in the SHIP. Ms. Cassavant was not denied access to any university program or activity on the basis of her transgender status or any other protected class.
What did she have? What did she wind up with for insurance in that year? You required that she have insurance, either enroll in the SHIP or produce other insurance, correct?
Yes,
Is that
and
what she did?
Ms. Cassavant opted for the SHIP program.
She did.
Yes,
And it did not provide the coverage, the gender affirming care. It was denied.
initially it was denied, Commissioner, but Ms. Cassavant filed appeals through the State Bureau of Insurance and directly to the insurance company. A reviewing entity was brought in to review the initial determination of medical necessity for these procedures at issue. And according to the record evidence that was submitted by the complainant, she succeeded in that appeal. And
Right.
in the process,
I think these things have evolved over the last couple of years, haven't they?
well,
The
certainly,
recognition of the medical need and that kind of stuff.
it is an evolving area of healthcare and science, and certainly the university is very supportive of Ms. Cassavant's needs, and those are matters between her and her healthcare provider, and it is up to each person to determine what healthcare insurance program best meets their needs. As an analogy, in the workplace, for instance, there are often choices as to which health insurance program you enroll in. It's never mandatory to enroll in a health insurance program. and each person has the ability to choose what best meets their needs. There are going to be students that have various health conditions and might require, because of their individual circumstances, a more comprehensive health plan. But the cost involved to offer multiple health plans, multiple options, just not feasible for us as a university system.
But you shopped for this plan, you sent out RFPs, correct?
That's correct.
Okay. And you listed the requirements that you wanted them to bid on. This is not a plan that I can go to a website and say, I want A, B, or C. This is something that you negotiated on the basis of your 30,000 people to be covered.
Commissioner, respectfully, there is a way for anyone in the state of Maine, any resident in the state of Maine, to review health insurance plans by going onto the exchange website offered through the state of Maine, to review what best meets their needs.
Okay.
Any other commissioner questions for Attorney Salsick this time? Commissioner Douglas?
Yes, good morning. Just briefly, I noticed in your submission that you, and this morning in your presentation, that you referenced the fact that she, the student filed an appeal with the insurance company, and that appeal was granted. And ergo, she now has this person now has the coverage that they need. Is that accurate?
Yes, Commissioner.
Okay, and so I guess what I'm wondering is, I mean, are you making the argument that this whole proceeding is now moot somehow? I'm just wondering what the thrust is of that.
I think that's part of it, Commissioner. I think that fundamentally at the core of this case, the complainant is attempting to hold the university liable for the actions of a third party, and that is not anticipated by the law. There is no precedent for that. And so it's twofold, Commissioner.
Okay. Yeah, and I get that the thrust of your presentation, or a big part of your presentation, is that, this is the insurance company, it's not us. I mean, I think that the claim is that you had and it says this in the report, you could have asked certain questions, you could have requested certain coverage for this individual, and that you didn't do that. I think that's the basis for the claim. I mean, do you want to address that a little further, or?
Respectfully, Commissioner, there are multiple medical conditions that any one of our students could have. And, for instance, if a student wanted to pursue fertility treatments, conceivably that would be something that is not covered by every health insurance plan. And would it then follow that the university discriminated against pregnant people or folks wishing to become pregnant because an insurance plan that we offered did not necessarily cover IVF or another fertility option? I mean, there are so many medical conditions that unfortunately require extensive medical care, and it's beyond the scope of our ability to predict or plan for every possible medical condition that someone may need coverage for.
Okay. All right. Thank you.
Commissioner Walker?
So after Ms. Cassavant appealed to Anthem, and Anthem ultimately granted coverage for these services.
I'm sorry to interrupt. I
I'm
just
sorry.
ask that you not use the name of the insurer since they're not a party.
Is the university's plan now cover these as medically necessary in the future? I mean, you had a determination that they would be covered. So I guess my question is that a case by case determination, or now does the plan cover every potential service.
From what I understand, Commissioner, it's still a case-by-case determination. The university does still offer a health insurance plan. We, for instance, during the current school year, we had less than 500 students enroll in the health insurance program, presumably because there are other options available.
Thank you.
Any other commissioner questions for respondents council at this time? Seeing none, you'll have about 2.5 minutes when we come back.
Thank you.
Good morning, commissioners. I'm Kristen Aiello here for the complainant. The investigator is correct in her recommendation that there are reasonable grounds to believe that discrimination occurred. Interestingly, the facts in this case are largely undisputed and relatively limited. August 2019, the complainant enrolled in the university. She had to show proof of insurance or automatically enroll in the SHIP. In August of 2019, complainant enrolled in the SHIP. Thereafter, complainant underwent gender-affirming medical procedures. In November of 2019, so began denials and appeals of insurance coverage under the SHIP. In February of 2020, my client's mother, who is here with us today, finally received a copy of the insurance policy. The insurance policy classified gender-affirming care procedures, including the care that my client received because my client is transgender. They qualified this as cosmetic and automatically excluded. There's no individualized assessment. There's no look at whether or not it's medically necessary. It's not on the menu. Therefore, my client was automatically not eligible for coverage. So once my client's mother found this out, she immediately contacted the respondent, the university, and stated that she believed the SHIP offered to students was discriminatory and violated Maine law because it excluded care for transgender students. Thereafter, mom also contacted the university's risk manager and reported insurance denials of complainant's gender affirming procedures. Mom stated she believed the SHIP that was offered to students was discriminatory against trans students because it had a blanket exclusion for gender affirming care. So that's really important to remember. This was on the list of procedures that were explicitly excluded, period, done, end of story. We won't even look to see if it's medically necessary. We've already decided that it is unnecessary. We've decided that it is. Mom followed up with an email. She provided a copy of the complaint that complainant had filed with the Maine Bureau of Insurance. And she also provided an article from Benefits Magazine from August of 2019 entitled Transgender Health Benefits Best Practices and Legal Considerations. Lo and behold, unbeknownst, of course, to the complainant, in the spring of 2020, as Commissioner David pointed out, in preparation for the new school year, respondent worked with another broker to choose a SHIP for the following year. The broker presented several plans for respondent's consideration and for respondent to offer as a benefit to the student body. They could have chosen another policy. They could have negotiated, making sure that this didn't contain discriminatory terms, but they didn't. They selected this plan based on a number of factors, including low deductibles, no cap on coverage for athletic accidents, but complainant's concerns as a transgender student in a protected class were not raised or discussed when the university negotiated this plan. So the law is correctly cited in the investigator's report. The investigator being the sole person who's unbiased, who looked at the facts, who talked to the witnesses, who collect the evidence, and correctly applied the facts to the law. So again, the undisputed facts are that the university offered a comprehensive student and health insurance plan for its enrolled students. They offered this as a benefit. And the university, there's no dispute that the university was in charge of negotiating the benefits package and could include certain provisions in the benefits package. They didn't. They categorically excluded care, gender affirming medical procedures that transgender persons may need. The university's response, just to go through a number of the points that the university made, Anthem initially denied coverage, not University of Maine. That's actually not correct. By choosing this plan that categorically excluded treatment for transgender students, the university denied coverage because it was off the table. It was not on the menu. University argues that that they didn't discriminate. The claim solely relates to the denial by an insurance company. The university says they have no authority or involvement in determining coverage for specific medical procedures. Again, this argument fails. The claim before you doesn't relate to the insurance company's action. It relates to whether a benefit offered by the university, an insurance plan that includes categorical exclusions for transgender care, was discriminatory under the Maine Human Rights Act. And the investigator was correct that it was discriminatory. The university has authority over the benefits that it offers to students. The university has the obligation to ensure that the benefits that it offers to students don't discriminate against any protected class. The university says that no, it wasn't a problem, it wasn't our fault because the enrollment was voluntary. This argument is clearly without merit. The student health insurance plan is a substantial benefit that's offered to all university students. My client was an enrolled university student. My client should have been entitled to equal access to this plan to decide, is this a plan I want? Part of that analysis shouldn't be that, oh, it is discriminatory, so I can't choose it. That's not reasonable at all. If a plan includes categorical exclusions for care the student may need, this plan is not reasonable, and the student is unable to take advantage of the benefit that the university offers. And again, this is super important in terms of what the law says. Public accommodations, educational institutions may not discriminate with regard to its program services and benefits that are offered to the student body. By taking transgender care off the menu, completely off the menu, that is discrimination, and that's a failure to ensure that to meet its obligations under the Maine Human Rights Act. The university argues that because complainant ultimately prevailed in her appeals, the slate is clean and there's no discrimination from the university. Again, this argument fails. It is true that complainant ended up getting covered 80% of the cost for her transgender care, but this is after 2.5 years of being denied coverage, ultimately being reimbursed 80% after 2.5-year fight with the insurance company over the blanket and automatic exclusion for gender affirming care. And again, the university had control over what is part of its benefits package. It allowed a blanket and automatic exclusion for the care my client needed as a trans student. Complainants' peers who are not transgender are not forced to appeal and fight for coverage for basic care under a benefit offered by the university. Complainants' claims were repeatedly denied due to the categorical exclusions for transgender care in the benefit that was chosen by the university, not once, but even after they are on notice twice. The fact that complainant, through her own and her mother's sheer will and persistence, was able to ultimately get coverage has no bearing on the fact that the university negotiated and offered a benefit that categorically and automatically discriminated against transgender students by denying the care that they specifically may need. There are reasonable grounds to believe that the university discriminated against complainant who is transgender, and the discriminatory conduct concerns an activity enumerated in the Maine Human Rights Act, as the SHIP was offered to the student body as a benefit of complainant's enrollment as a student. And finally, respondent treated complainant less favorably than other students as it selected an insurance plan that denied coverage to an entire population of students on the basis of gender identity, and continued to select that plan despite knowing that the plan did so. And I'd like to just underscore here the policy underlying the Maine Human Rights Act and the Commission's role, very important role in that policy. Again, Section 4552, the policy of the Maine Human Rights Act is to protect the health, safety, and welfare. It's declared to be the policy of this state to continually review in all practices infringing on the basic human rights to a life with dignity and the causes of the practices, so that corrective action may, where possible, be promptly recommended and implemented. This is such an important case for the commission to find reasonable grounds on, because it will place this case in conciliation. It will allow the commission to look at the policies now in place, to answer the question about whether or not their policies that they offer discriminate or not against transgender students. So again, this is a very important case. Reasonable grounds clearly were found. And I'd like to again emphasize that the one person, you've heard from me, I'm an advocate for my client, you've heard from respondent's attorney, we are advocates, but the one person who was assigned to look at the facts, collect the information, and write the report was that unbiased person, your employee, the investigator. And her report absolutely deserves to be upheld, and reasonable grounds should be found. So thank you for your time.
Oh, sorry. I apologize. Not exactly 10 minutes.
Shocking.
I'm sorry.
I was thinking I must be
You
going.
were right at it, but I was just about to tell you. So apologize. Well, that's your time. Ms. Ayala.
Thank you.
Commissioner questions for Ms. Ayala.
Your argument mentions the fact and is made stronger by the second year of getting the same policy. Am I correct that you would, if that hadn't happened, you would still say it was discriminatory even on the basis of the first year?
Yes, Commissioner.
Right.
Absolutely.
It's not essential that they did it again. It just confirms the fact that they were, whatever you want to say, callous, ignored it. It was one person out of 30,000, whatever.
That's right, Commissioner. I agree 100%.
And there's no medical issue here. Is there, did the insurance company ask for a medical justification from her physician saying that this was indicated for her gender affirming care?
Well, that's the whole problem, Commissioner, is that it was off the table. This care was off the table.
Because it was categorical.
Because it was categorical automatic exclusion, which is just so blatantly discriminatory.
Thank you.
Thank you.
Other commissioner questions for complainants counsel? Commissioner Douglas?
Yes. Good morning. Good morning.
Commissioner.
Here's what I'm struggling with. I mean, so I'm a person that deals with insurance companies all the time, as you probably are as well. I mean, this is what they do. They limit coverage, they deny coverage. And I thought I saw something in the record the first time I reviewed this case, but I'm not seeing it today. And I'm curious, was there a policy available that characterized these procedures that your client wanted as medically necessary and not cosmetic?
Was there a policy out there other than?
Yeah.
I did see in the record some information from complainant's mother that indicated there was a policy, and we're not supposed to say names, so I won't, but there was a policy that did offer this care. The university did not choose that policy and did not negotiate the benefit. And keep in mind too, that just because this is off the list of automatic exclusions doesn't mean a person automatically gets any care. There has to be an analysis that goes in, an individualized assessment about whether or not care is medically necessary. The problem with this is that it was off the menu, it was off the table, and it excluded a whole population of transgender students in the university. So there should be an opportunity to assess cost, to assess need, but there wasn't even that.
Okay. And so relative to the insurance company's characterization of these procedures, right, as cosmetic and not medically necessary, do I understand your argument to be they're medically necessary because they're gender affirming? That's very important to a trans person. Is that the argument?
It is. And in fact, at the fact-finding meeting, the complainant noted that it just described how it was very important because it really made them feel more comfortable, if I may, and not wanting to kill themselves. This was found to be medically necessary after it went through the appeals process at the Bureau of Insurance. So there's no question about that. The issue really here is what the university did to allow this automatic, outdated exclusion rather than, allow that to be an option on the menu.
Okay. All right. Thank you.
Thank you so much.
Any other commissioner questions for complaining counsel? Seeing none, thank you.
Thank you very much.
At this point, we'll have respondents counsel back for 2.5 minutes.
Thank you. Responding to complainants counsel's arguments, again, the conduct complained of was engaged in directly by the insurance company. The University of Maine system had no role in determining what was medically necessary, whether a procedure is medical or cosmetic. That is solely the act of the insurance company. Again, the insurance company is not an agent of the university. We did not have any part in determining whether these medical procedures were covered or allowable. And to hold the university liable for the actions of a third party is simply antithetical to the law here. The act to expand coverage for Maine persons signed into law by Governor Mills in 2019, again, regulates insurance companies. There is no mention of employers or universities or any other entity that offers an optional healthcare plan. I would also add that Ms. Cassavant was not denied access to any program or activity that the university offered directly. The health insurance plan was optional. Had she been denied the ability to enroll in health insurance based on her transgender status, that might be an instance of discrimination, but she was not denied access to health insurance. It is a benefit that the university offers. It is optional, but the nexus here is far too attenuated to hold the university liable for the actions, again, of a health insurance company we are not affiliated with, and we were not involved in any of the proximate conduct that led to the initiation of this complaint. Ms. Cassavant has not been denied access to a dorm. She has not been denied access to classes or anything.
Sorry, that's
Thank you.
your time.
When I'm focusing on the second year, you are notified by mom that this is discriminatory. She makes that allegation, says, here's the reason it's discriminatory. It's medically necessary for my daughter's care. Do you evaluate that claim of discrimination and say, in effect, we don't care, we're going to have the same plan again? Or do you evaluate it and say, yeah, it's discriminatory, and go to bat with the insurance company to negotiate some different term?
Commissioner, I think that's not the analysis that the university engaged in. Our risk manager did encourage Ms. Cassavant to pursue the appeal process with the insurance company. By the time that we were in the position to engage with the insurance company and the broker again, we did not have an outcome in this matter. The appeals had not been decided until early 2022. By that time, the insurance plan had already been engaged for that school year. We have a timing issue here.
Thank you.
Any other commissioner questions for response counsel? Seeing none. Thank you very much. So the investigator who worked on this case, Courtney Byrne, is out due to an emergency today. We have Kit Compton Crossman, our deputy counsel, who worked on this case from a legal perspective and is presenting Courtney's findings.
Thank you. I'll be brief and then I'm happy to answer any questions that you may have. How about this? I do want to emphasize the SHIP is a benefit of enrollment at the university. I'm happy to answer more questions about that, although I think that complainants council covered that pretty thoroughly. I do want to make so respondent does have control over what is in the SHIP. At the time that complainant sought this care, they had chosen this plan that had these categorical exclusions. At the time when they picked the plan for the second year, they knew that complainant had been denied, I think at least twice at that point. They knew that these procedures were not covered by the plan. They didn't even ask the broker if it was possible to have these procedures covered, how much it would cost to have these procedures covered, what the reasoning was for the blanket exclusions. They didn't investigate that at all. So there is no argument right now about, well, it would have cost too much or it would have been prohibited in some other way, because they don't know. They never asked. Even though they were on notice that complainant had been denied these procedures, they didn't ask if it was even possible. And they do ask the broker to make sure that the insurance plan that they offer covers other pretty specific things, the athletic injuries covered for international students, covered for other kinds of students. They do ask for very specific things that are different from other insurance plans that are on the market because they're a university. So they can ask. They can always say, no, that's too expensive, we don't want to, but they never asked. They never did any investigation into whether or not it was even possible to cover this. And so they are responsible, they are liable for the denial because they pick the plan. They, through their broker, direct the insurance company to provide a plan that covers certain things. So they are liable for the denial. I'm happy to answer any questions that you have at this point.
Commissioner, questions for Kit, who is presenting the investigator's report?
Yeah.
Mr. Ryan?
Just one real basic, when you categorically deny, that does not mean that they know, right? I mean, is it saying no transgender? I mean, is that really delineated?
Yeah, so in the policy, which I'm sure this has been said already today, I just want to make sure we all know that complainant had been asking for a copy of the insurance plan for months before she ever saw it. So she asked for the care in August. She asked for a copy of the plan. She asked for a copy of the plan. She asked for a copy of the plan. She didn't get it till the end of January the following year. But yeah, it is in the plan. These procedures are absolutely not covered. So if you read the plan, which is in the record, you can see this is not here. That's good. Yes.
Commissioner Davis?
To follow up on that, Kit, it's saying, I don't think I realized that the first time around. Plan is saying that that procedure is not covered. It's not just the case that the adjuster or the in-house person says denied cosmetic.
Yeah.
It's that's a procedure that's not covered.
My understanding is that at the time she sought the care, there was a blanket exclusion. The next year, the language changed slightly. And I have read it several times and I would just say I also have done a lot of insurance stuff in a previous life. I still can't quite make heads or tails of it, although it does seem to me to say that if the person is seeking these specific procedures that complainant got as gender affirming care, we're probably not going to cover them anyway. If they need them for some other medically necessary reason, maybe we'll cover those.
And on another topic, does the record indicate what the deductible is generally? I mean, I guess that's the question.
That I don't know.
Suspicion is that part of the benefit of the plan for students is that it's a low deductible, that it's a generous coverage.
Yeah, I could go through the record and answer that. I'm not sure what the specific is. I know the premium, I think, for the first year was about $2,100. total for the annual coverage, but I don't know what the deductible was off the top of my head.
Commissioner Douglas?
Yeah, thank you and good morning. I'm just trying to confirm, I mean, so during this period of time where these procedures are contemplated and the insurance is contemplated, was there a comparable plan that the university could have? I mean, I get the procedure whereby we contact the insurance company and we say, oh, hold on. You know, we have somebody here that needs these procedures and you need to cover them. I get that. But outside of that sort of appeal, review, question process, was there a plan, a comparable plan that the university could have opted for instead of the plan that they ultimately got?
I can only say, I can tell you what is in the record, which is that in, I think, February of 2021, the respondent was made aware that there was a comparable plan. It is not in the record how long that plan has been available. It is offered by another very large insurance company that does this sort of stuff all the time. And I understand the question, where that question is coming from. I do just want to point out that respondent, whether or not respondent knew that there was a comparable plan when complainant was seeking care in summer of 2019, by the time they went to pick the plan for the second year, which might not have made a difference to complainant's coverage for those procedures initially, for any future coverage for her that she was looking for, respondent knew in March of 2020 that those procedures were not covered by the SHIP. They picked the same SHIP again without asking the broker whether it was even possible to get a plan that did cover those procedures. And I complainant did provide a comparable plan to respondent, but ultimately respondent is the one who is picking what the SHIP is. Respondent is the one who is dealing with the broker, and it's a pretty simple question to say, hey, can we get these procedures covered at all? Is that possible? Is there a plan out there that would do that? They certainly do that for several other very specific things that they're looking to have covered. So by March of 2020, they knew that these procedures weren't covered. They still picked the same SHIP. And as far as I know, as of the end of the investigation, the last footnote, I think, in the report is that that SHIP is still what's offered, and it's still not clear whether those procedures are covered. Even after the appeals, even after the commission.
Okay. All right. Thank you.
Commissioner Walker?
Do I understand, are there some transgender medical services that are covered, and then there's a list that are excluded? And these services were on the list that's excluded. Thank you.
Any other commissioner questions? Seeing none, thank you. Thanks. So commissioners, you've heard from the parties and you heard the presentation of the investigator's report. At this point, we would be looking at the proposed finding. There is one proposed finding that we would be looking for a motion. Commissioner David?
I move that we find that there are reasonable grounds to believe that responding university system discriminated on the basis of sex and sexual orientation or gender identity. Conciliation should be attempted, and I'll speak to that if it's seconded.
Is there a second?
Second.
So it's been moved and seconded to find reasonable grounds to believe there's unlawful discrimination. Is there any discussion?
Yeah, I mean, I've tipped my hand in this, and the reason is because I've lived with it for the 4 months that we've had it, and I remember it, and I've thought about it many times. Counsel for the university says we didn't discriminate. It's a third party, and we're not responsible for a third party's discrimination. I think that's precisely wrong. The insurance company created the policy that it created. It also created its procedure to determine that a particular request is denied because it's cosmetic, and also created the list of exceptions. That's their insurance policy. The university's discrimination is in picking an insurance policy, standing by it, and offering it to 30,000 students and requiring that they take the policy when that policy, that's the discrimination, is offering a benefit to the majority of students that denies it to the few. And that's discrimination. The law is in effect. The law is in effect at that time. And I understand that we're in a social evolution in terms of trying to bring insurance companies along, which takes litigation and years, and eventually it's happening. But the law is in effect. The discrimination is there, saying, and they're not curing it. And the nail in that argument is the second time around. Once they clearly know, I'm not quite sure what I would have done had it only been the first year. I think I still feel that it's discriminatory. I think I would have said, well, let the university pay for it out of its pocket, but that would be a different argument. But the second time that they do it, it's discriminatory. It violates our law.
Any other discussion from commissioners? Okay. Mr. O'Brien?
I guess that does not persuade me whatsoever. I don't think that looks at the pertinent question, and that pertinent question from my perspective is, what is the obligation of the university to their students? I think they're trying to meet that. There is a long list passed by the legislature of mandated benefits that must be included in a health plan, and from what I gather, that's not been presented. This is not one of them. So then you ask the next question, and my analysis is, if we were to award this, are we expanding the law beyond what the current law is? And I'm no expert in the interplay between the laws that were passed and the insurance laws and mandated benefits. I too have some extensive insurance background. I actually managed, from a legal perspective, a group insurance plan of many thousands of people. And I don't know the answer to the question that I posed, but I think that's the pertinent question, and not how you're looking. I'm not 100% sure what I'll do on this, but I think it would be expanding the law, and maybe it should be. But I ask whether this is the appropriate forum to do so. So, thank you.
Commissioner O'Brien?
Well, I think as the second time around, for some reason, I'm hearing things differently. Perhaps it is the second time. I'm hearing something differently, and so, Mark, don't necessarily follow me. I don't know. I'm very conflicted about it. I will say that.
Any other discussion, Commissioner Douglas?
Yeah, I think this is it's a tricky case from my perspective. I mean, we have I'm not satisfied that I'm trying to envision this in sort of a real world, how this went down sort of way. And I can see, on the one hand, you have an insurance policy. Maybe you have people that believe that this is it. This is sort of a standard insurance. These are standard insurance provisions, right? Cosmetic versus medically necessary. Not much to be done about it. And I'm not satisfied that there was a comparable policy out there that was available for them to get during this period of time. I think what swings it for me is, when the university is made aware that, that one of their students feels that this is discriminatory, this coverage is excluded. What I heard this morning is that the university is willing to advocate for other folks and to look into sort of expanding coverage, obtaining coverage for other people, but they did nothing for this student. And I think that's what swings it for me. So, but I think it's a difficult, nuanced, sort of tricky case. I do.
Any other, Commissioner Davis?
Yeah, Mark, it seems to me that what I'm hearing and I'm sympathetic to is the insurance company and whether you're feeling that a finding of discrimination would be against the insurance company. I don't think we're expanding the law. The law is in there. You public entity cannot discriminate on the basis of gender. It's the university that discriminated. It discriminated by buying this policy twice, and it's not the fact that their hands are tied. They negotiate this policy. They say, we have health centers. We want a policy that covers health centers on campus when a student comes in with mono. We want a policy that covers our athlete when he breaks his ankle and it goes bad and it goes on for years and it's unlimited coverage. They could have negotiated this. We want gender affirming care. It's in the law. We've been notified. We're going to get sued. You know, whatever they say to their broker. So that's my focus, and I don't think that's an expansion. I think it's an application. It's an application of a new law. Our social understanding of discrimination is growing and expanding, and that's what's vital and exciting about this commission. So, thank you.
Any additional discussion from commissioners? So, at this point, we have a motion to find reasonable grounds to believe that unlawful discrimination occurred. We have a second, so at this time, I'll ask for your votes. If you agree with the reasonable grounds finding, you will vote yes. Commissioner Davis.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
No.
Commissioner Douglas.
Yes.
So the vote is 3-1-0 with 3 in favor, 1 opposed, and 1 abstaining. For the finding of reasonable grounds, the commission will send council a letter confirming that, and thank you all for your excellent presentation.
Never go on with it.
You have, I know, right? Okay, good. You're all set.
I'm really frustrated.
I
let it know.
I know you did.
Next on our
Yeah.
agenda, case to be heard is PA 21003. That is Chevrier versus the Maine State Prison. This is a no reasonable grounds case, and as a result, we would hear from the complainant.
So, so you all know my understanding. So Mr. Chevrier is incarcerated. My understanding is that he will be with a case manager who will make his participation possible. Is that correct?
That is, are they on the phone?
I don't know. There's some people on the phone, but I don't know who they are. So if you are here with Mr. Chevrier and you're on the phone, can you please unmute yourself? So far, I don't see anyone.
Good morning.
Ah.
Good morning. This is Mr. Chevrier.
Okay, so Mr. Chevrier, this is Amy Searson. You'll have 10 minutes to make your presentation to the commissioners. And I'm not sure if you heard the introduction earlier that we ask that you not use the names of anybody who's not a party. So any witnesses or people who work for the department, but who are not the department themselves or the Maine State Prison. Okay?
Yeah, that's absolutely understandable.
Okay, so you have 10 minutes.
Yes, ma'am.
Go ahead.
All right, thank you very much. Good morning. I'm here to present my argument in regards to discrimination, in regards to ADA violations by the Maine Department of Corrections, meaning the Maine State Prison where I am confined. The holdings in regards to the Maine Department of Corrections and Maine State Prison state that I myself am not a qualified individual with a disability, and that I'm currently engaging or was currently engaging in the use of illegal drugs prior to the request of medical assisted treatment by the way of Suboxone to combat my substance use disorder, opiate use disorder.
and to include the fact that I'm not entitled to treatment of my specific choice under the Americans with Disabilities Act. I'd like to close the following argument. I, Jonathan Chevrier, am a resident incarcerated in the Maine State Prison, a facility under the Maine Department of Corrections. I've been diagnosed with substance use disorder in connection with my use of opioids, and have been diagnosed with the Department of Veterans Affairs. I am a 100% service-connected veteran suffering from post-traumatic stress disorder with chemical dependency, cocaine, heroin, and alcohol. I have asserted that the developed dependence has been based off of being prescribed medication while in the Department of Corrections that have not been, I guess they just haven't been the proper medications, and the reason for that is due to the prison policy. I've turned to the illegal use of opioids while within the Maine State Prison, and through all the denials of being prescribed medications by the medical staff within WellPath, and who is the current medical entity within the Maine Department of Corrections. During my incarceration, my incarceration is due to addiction and the trauma that has been inflicted has been caused by, substantial stress associated with combat stress and deployment injuries. I believe that initially I was prescribed medications that being helped with pain. I was taken off these medications, and because I was taken off of these medications, I initially turned to the use of illegal drugs within the prison. And turning to these drugs within the prison, led me to having these initial behaviors around drug-seeking behavior, which prevented any further medication being prescribed to me through the prison. And eventually I turned to self-medicating myself due to not being able to have any type of prescription medication that was specifically for pain. And I originally tried to be inducted into the MAT in February of 2020 and submitted all of my evidence in regards to a diagnosis of opioid use dependency through the VA to include additional information that was provided within documentation from the respondent to the investigator, Kit Thompson Crossman. After exhausting all my remedies within the Maine State Prison, I filed a discrimination case with the Maine Human Rights Commission. The Maine Department of Corrections has denied the MAT solely based on the fact that I did not meet the requirement or the criteria for early induction while it was still available. I submitted requests for early induction in February and April, and early induction was halted in December. And the DOC alleges that in fact they submitted individualized assessments regarding medical and security considerations and the medical issues involving myself, to include the ongoing visits to the medical department, doesn't just specifically relate to chronic care. It also has contributing factors relating to me respectfully asking for admittance into the MAT program. I've met with several professionals in regards to substance abuse in the Maine State Prison. The majority of these meetings were due to failed urinalysis, possession of hypodermic needles while during my incarceration, and these decisions were based off of the unit manager's decision within the close unit. And I'd like to acknowledge the fact that under case number 273A.3D1260, case in point Mark Ricardo versus Pennsylvania State Department of Corrections, that talk therapy is not the same as medication treatment. The MDOC's response to my request does not indicate that the department afforded any individualized consideration to my specific circumstance to determine whether or not a departure from their policy may be warranted. With respect to that, if a physician were to determine my condition for treatment for MAT, and with regards to it being a severe medical need, that it may require the requested form of treatment. In response to treatments and doctors giving their assessments, regional medical director specifically stated and presented to the commission that I was presented with symptoms of opioid use disorder, to include cluster B personality disorder, which was submitted to the committee in April of 2020. And I believe this in fact shows that not only was I not given the opportunity to just seek counseling for substance abuse, but I was also denied services after a referral was submitted by a medical physician. The reports associated with these specific reasons are documented within the information provided by the respondent. The fact that the medical clinicians determined that providing non-opioid medication was the best course of treatment regarding the chronic pain does not specify why I myself was denied MAT for rehabilitation purposes associated with the acknowledged diagnosis of OUD that the Department of Corrections has had a reason to deny the access to the MAT. And the medical evaluation conducted upon myself did not qualify due to me actively using opioids during the time when I first requested MAT until I was granted access to it, which is a 16-month period. The determination of the qualifications surrounding access to MAT to specific qualified residents within the Maine State Prison, I believe, suggests that the department has made specific assessments that are inappropriate and unnecessary treatment regarding the specific infliction that has been put upon myself by them. Substance use counseling and non-opioid medication approach tends to ignore the reality of the situation, and the fact that I've been denied my requests, I believe it is pursuant to a categorical policy exhibiting MAT to the general population and the residents such as myself, and it appears that the entire category of medical treatment that the department's policies have made available, they don't prevent any prolonged suffering from mental infliction, to include forms of cruel and unusual punishment, regarding stress, anxiety, impulse control, panic attacks, and forms of those types of natures regarding stress. And I believe that, that in itself invokes the Eighth Amendment. The MDOC has applied due to the consent of illegal drugs that requesting MAT disqualified me as a qualified individual with a disability. Although I believe that can be argued and that the implication is in fact erroneously applied regarding to the fact that the statements to which I admit to using illegal drugs,
Mr. Chevrier?
the fact that, yes.
I'm sorry to interrupt you, but that's actually your time. Meaning you used up your time. So I'm sorry to interrupt you in the middle of a sentence, but that's what I do to everybody. So you're not unique in that regard.
Okay, I understand that. I guess
so
the only thing that.
Nope. That's like really your time. But hold on. I'm just going to see if any of our commissioners have any questions for you. So hang on. I see Commissioner O'Brien.
Yes. Hello. I think I am trying to synthesize this to the the base. And is it your contention that basically, is this about you were not allowed to, you were not given, there were exclusions to the policy that it had to be, you had to be getting out in 6 months. There are exclusions. You were not included because that you were using, they had evidence that you had used illegal drugs, and you're saying in the prison, and you're saying that you did that because they took off the Suboxone. Is that basically what it is?
The reason behind me continuing the use of illegal drugs within the system while waiting to be inducted into MAT is the fact that I was removed from taking any type of chronic pain medication due to the fact that they acknowledged myself as having drug-seeking behavior. And the types of medications that were given to me were psychological medications that deemed to have properties of helping with pain, but that just wasn't the case.
Thank you.
Any other commissioner questions for Mr. Chevrier? Mr. David?
Mr. Chevrier, it basically, to follow up on what Commissioner O'Brien just asked you, it's that you were denied admission into the program, right?
Yes, sir.
Okay, and they say that that's because of space availability and time requirements of the program. Is that not correct?
I don't believe that to be correct, sir. There's multiple individuals that had almost 3 times as much of a sentence left, if not more, and they were inducted during early induction, which basically happened throughout the entire year of 2020. It halted in December, began in February. I initially requested to be a part of the early induction and submitted all the information pertaining to the policy under which states that an individual with a known disability of opioid use dependency would be admitted into the MAT program. And with doing so and seeing that other individuals were admitted into the MAT program with a sentence longer than mine, well, with regards to a release date, they were inducted into it. And I believe that even the fact of knowing that I am, in fact, a qualified individual with this impairment, that I was excluded from participating.
But do they say to you that you're not qualified on the basis of your disabilities? Are they challenging that you have those disabilities?
Yes, sir. Yes, sir. They have challenged it on several occasions. One specifically with the fact that the illegal drug use will exclude an individual, from the definition of an individual with a disability.
Okay. I hear you. No, thank you.
Any other commissioner questions for Mr. Chevrier? I am not seeing any right now. Mr. Chevrier, oh, no, sorry, we have one more.
I'm sorry, a quick one, I think. We're talking about the exclusion. If you were to be released within the 6-month period, would you still be precluded because your use of illegal drugs in the system?
I'm sorry. There's a lot of echoing. I couldn't hear you, ma'am.
If you are basing this on that you were excluded from being in there, it was an exclusion. If you were within the 6-month period for release, would you have been included in the program, allowed to participate, even though you had evidence of using illegal drugs in the system?
That's kind of hard to determine. I know that there's other people that are in my specific situation and I can't speak on their behalf. All that I can speak in behalf of is myself currently, and I know that with regards to that, that the exclusion was based off of not only the 6 month window from release, but it was also based off the fact of not being a qualified individual.
Okay.
And
Any other commissioner questions for Mr. Chevrier? Seeing none. Thank you, Mr. Chevrier. I'm going to mute you, and now we're going to hear from respondent.
thank you.
Good morning, Commissioners. My name is Jill O'Brien, and I'm representing the Department of Corrections in this matter. I think there's a bit of confusion about the facts, and there is a lot of material here in the record, so I wanted to make sure we're all operating with the same facts. So Mr. Chevrier has been on medication-assisted treatment since July of 2021. There was a period of time before that that he was not eligible. When the program was rolled out, it began within for those within 3 months of release in hopes of stopping deaths from opioid overdose upon release from prison. It was quickly expanded to cover residents within 6 months of release, then within a year of release, and by the summer of 2021, it was universally available to Maine State prison residents with opioid use disorder for whom the doctors had decided it was medically necessary. And there's a process by which you have to have a drug test. You can't go on to MAT. Having that in addition to illegal opiates can cause significant health problems. So there is an induction process. And for those who were outside of the 3 month, 6 month, or 1 year period, there was an exception made in the case of exceptional circumstances, that a panel of medical providers would examine a case and decide if exceptional circumstances warranted early induction. Approximately 8 total residents were inducted early because the circumstances in those cases were truly exceptional. Here, Dr. Propp examined Mr. Chevrier's case and found that he did not meet the exceptional circumstances, and his case was not presented to that committee. You can see from Mr. Chevrier's complaint that he was challenging denial of medication-assisted treatment. It's the first time hearing about him complaining about being taken off pain medications. He's been prescribed Lyrica, several pain medications, carbamazepine. So his disagreements with his doctors about the appropriate pain medication is not an Americans with Disabilities Act claim. He may have medical claims that he wishes to pursue if he doesn't believe he's getting the right medication for pain, but that's not what the commission is here to decide. The investigator pointed out that the federal laws preclude from the definition of disability someone currently using illegal drugs. So that's where that issue is coming from. So in addition to the fact that there wasn't a period of sustained sobriety that would qualify him under the federal law, Mr. Chevrier worked in the laundry. He was not substantially impaired in any way in his major life activities, rendering him not a qualified individual with a disability. And as a final point, he was not denied benefit of the MAT program by reason of any disability. It was because the prison had to do an orderly rollout of this program, which requires the providers to get waivers to be able to prescribe these dangerous medications to more than a certain number of people. It's a heavily regulated system. So he was denied by reason of the length of his sentence for a short period of time. It is now available to him because his providers have deemed it medically necessary. So the department was not discriminating against him. Happy to answer any questions you may have.
Any commissioner questions for Respondents' Council? Seeing none. Thank you very much, Ms. Craig. So commissioners, so next we're Courtney. No, Courtney, this was not Courtney. This was Kit Tom Crossman when they were still an investigator.
I don't have anything to add except to say that I don't think I said anything about federal law. The definitions I'm citing are under the MHRA. Our definitions for disability are slightly different than under the ADA. They tend to be broader, but the exclusion for somebody who is actively using certain classes of drugs is the same. I'm happy to answer any questions that you have.
Commissioner questions for the now council and the investigation.
It's going to end soon.
You will. Seeing none. Thank you, Kit.
Great, thank you.
So commissioners, you've heard from the party, you've heard from the person who investigated the case, and at this point, we'll be looking for a motion or motions. There are, I believe, 2 proposed findings here. You can take them separately or together. On page 4 of the investigative report.
I'll propose that we take them together. I move that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, and no reasonable grounds to believe that the respondent retaliated against the complainant for engaging in a statutorily protected activity, and that the complaints be dismissed in accordance with the act.
I would second it.
So it's been moved and seconded to find no reasonable grounds on both claims. Any discussion on commissioner? Seeing none. So the motion is for no reasonable grounds on both claims. If you say yes, you are in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
So both findings are no reasonable grounds, and the commission thanks everyone for participating. We will send a letter confirming the findings to all involved. Thank you so much.
Next on our agenda is MHRC case number H22-0253 A, B, and C. This is a finding in one case of reasonable grounds. So we would hear from respondent or respondent.
And I believe I saw Ms. O'Brien online.
This is Jonathan Brogan's case. Is this DeShane?
This is DeShane. I thought,
Okay.
hold on, I must have the wrong information written down, so.
Attorney Oldby is for the next housing.
Okay, I've got those confused. I'm so sorry. So Mr. Rogan, looks like everybody else got that right except me.
And forgive me, I called the case number, but the case name is Dominique Shane versus Auburn Housing Authority, Leah Landry, Jordan.
And I believe everyone participating is online. So, Mr. Brogan, you'll have 10 minutes.
Okay. Just before we start, I need to recuse myself from this matter.
Oh, okay. Thank you. You want to turn off your screen, your video there, Tom? Thanks. Okay, Mr. Brogan. If you're talking, we can't hear you.
I was muted. I
There you go. All right, there you go.
Thank you. And good morning, Ms. Pearson and commissioners. I'm Jonathan Brogan, representing the Auburn Housing Authority. We are here today because of an unfortunate disagreement between Ms. DeShane and employees, or well, she says 2 employees, but 1 employee particularly of the Auburn Housing Authority. That disagreement led to some words from both sides that were certainly difficult. Some might even call them hostile, but were not race-based and were not based on a ongoing disagreement with Ms. DeShane because she's a woman of color. The record, and actually there's little disagreement as to the record, but I'll give you a little bit of the background on. In June, Ms. DeShane's apartment started having some significant difficulties. The AHA responded, and when they came in on June 29th, they found a leak, which was repaired, and then they had to come back the following day to finally fix it. And to fix it, they had to turn off the water. Apparently, when the water was turned off, there was disagreement on the part of Ms. DeShane because she did not want the water turned off. She was frustrated with what she perceived to be the lack of alacrity by the Auburn Housing Authority to her problems. And so it was a difficult and trying issue for both the Auburn Housing employees, who were getting, as the investigator correctly pointed out, a lot of difficult words from Ms. DeShane, and who unfortunately at some point reacted. Now, I know the commission knows that reaction is disputed. The employee says that he did not use a racially tinged comment. And in fact, there is an affidavit now from another employee or an employee of an outside contractor who was there saying the same thing. There's also an affidavit from one of Ms. DeShane's neighbors saying that this was said. Ms. DeShane clearly was frustrated. The employee was clearly frustrated, and there was disagreement between the two of them. But the leak was fixed, the area was tested, and it was determined that, in fact, her apartment had, as did all the other apartments, there were 6 apartments in this building, had mold damage from this leak. So because of that, the Auburn Housing Authority needed to move out all of these people from this housing project. And they did that. And all of the people were moved out, all of them were moved to a hotel, and all of them received the same benefits as was found by the investigator in the terms and conditions portion of this decision. The real issue becomes whether or not there was, in fact, a hostile environment that was created by this one interaction. Our argument is actually fairly simple, and it's been the same from the beginning. There's nothing within the facts or the law that supports a reasonable basis to believe that unlawful discrimination occurred on the basis of a hostile environment. There's nothing that shows that because Ms. DeShane was a woman of color, that she was treated differently because of this obviously protected class status. There's no evidence, and this is really important, that this ever happened before, since, or ever amongst either the Auburn Housing Authority employees or this specific employee who denies that this issue took place. Hostile work environments, as the commission knows, involve repeated or intense harassment, sufficiently severe or pervasive to create an abusive housing environment. All of the circumstances, including the frequency, discriminatory conduct, its severity, and whether it's physically threatening or humiliating, or a mere offensive utterance, is important. And in this case, there is one disagreement. That one disagreement seems to be what the investigator used to make a determination. And that determination, as you know from the footnote, was that there was a neighbor who said that they heard this disagreement. That person was not spoken to at the nor did she appear. She has not been cross-examined, nor have the circumstances of how she heard it, when she heard it, or any of the other things occurred. But there was another witness as well who says that it didn't happen. And of course, the two people involved, one say it happened and one say it didn't. What we do know is Ms. DeShane was treated the same as the other people in the housing project. She was treated the same afterwards. She's been treated the same since. And this disagreement is not part of some pervasive scheme or problem with Ms. DeShane. There is no evidence of severe conduct, repeated behavior, or even any similar behavior. This single utterance is not enough to apply the term race or racist to the interaction between people. That term is, as anyone knows, the worst scarlet letter that can be applied, and Auburn Housing Authority and the employee don't deserve it. And most importantly, Auburn Housing Authority, as the commission knows, there were 6 families in this building, 3 white, 3 non-white, all of them were treated the same. So there is no evidence of racial discrimination here. There is evidence of an unfortunate and difficult disagreement, but that disagreement was not based on race, it was based on personalities. Thank you.
Thank you, Attorney Brogan. Hold on just a second. Any commissioner questions for respondents council? Not seeing any, wait, can you bring Commissioner Douglas back up there? I cannot see him.
He's recused.
Oh, right, he's recused. Sorry, my bad. Sorry, Chelsea. Any commissioner questions for response council? Not, Commissioner David?
Is your argument primarily that it was just the one incident and that does not create a hostile environment?
Yes, primarily, Commissioner David, is that it was one incident, that it was not something that happened before or after, and that Ms. DeShane was not treated differently than any other family there, and her family was not treated any differently than any other family there, both after this leak was discovered and when they needed to be moved.
Thank you.
Any other commissioner questions for response council? Seeing none, Mr. Groby, you'll have almost 3.5 minutes left when we come back.
Thank you.
So then we would turn to complainant, Ms. DeShane. I'm sorry if I pronounced that wrong. So you'll have 10 minutes, and I'd remind you not to use the names of any third parties. I'm going to step out for a minute, but Commission Counsel Barbara Archer Hirsch will be keeping track of the timer. And I'll be right back. So go ahead, Ms. DeShane.
Okay, well, there is evidence that I have sent to the Human Rights Commission to show that it has been, I had called, well, first of all, he was wrong. All of this happened in the beginning of April, end of April, beginning of May. That I've called Auburn Housing 22 times within that time and letting them know that my floor tiles were coming up off my floor. So, in the time that they finally came, they sent a young man there to come and look at my floors. He knocked on my door and then he just walked in without even being addressed. He looked at the floors and then walked out. There was no conversation, no communication, no nothing. A month later, that is when Mr. Jordan came in with this young man, and by the time that they came in, I had no floor tiles on my floor. Out of the whole 6 apartments, I was the only one with no floor tiles. On June 21st, I sent an email to Leah Landry because I went and talked to her about my floor tiles. I sent her an email of a big chunk of my floor tiles missing out of my living room floor. It took them another month to even come back and even look at the floor tiles to see even what it looked like. We were walking on the subfloor and black mold for at least 2 months. My kitchen floors were heated, and I was blamed for flooding my floors from my kitchen to my living room by Mr. Jordan. And then he informed me that there's no pipes underneath my building. So I'm like, if my floor is heated, there must be something wrong with the pipes. He informed me that there's no pipes underneath my building, and then told me that my deep freezer was the cause of my heated floors, which the same deep freezer I have at the hotel that we're staying at, which is perfectly fine. So then from the end of April, the beginning of May, I'm calling about these floors, and nothing is getting done. Yes, I was very irritated on the day that he came and said, we're turning the water off. There was no notification. There was no 24-hour notice. There was no letter sent out. My kids were in the shower because it was a really hot day that day. One of my kids was in the shower and he had soap all over his body when they turned off the water without any notice. So yes, I was very upset at this point. So I get my son taken care of. I'm walking out back. So I left my cigarettes out back at my neighbor's house. And yes, I was talking to myself about how frustrated I was, which I have every right to do because I've been dealing with this situation since the end of April, beginning of May, and nobody has come to even take a look at the floors before they even got to the point to where we all had to be vacated out of the apartment. So as I'm walking back into my home, at this point, I'm walking back. Every single Nason was downstairs in the basement, and my neighbor was in her house. Her windows were open. So as I'm walking back, me and Mr. Jordan did have words going back and forth. He tells me that I need to shut the fuck up. I tell him he needs to do his job correctly. He then says, well, if you people leave, then I'll be able to do my job correctly. I then state, what does me and my family have to do, living here, have to do with you doing your job correctly? Then he goes to the truck, he turns around and he says, shut the fuck up, you black bitch. I then proceed to go into my home, very angry. I did not yell and scream outside. I went in my home, and that's when I started yelling and screaming because I was very upset. Because I've never, even though I am a black woman, I've never had to experience racism in the state of Maine. This was my first interaction dealing with racism in Maine. And because I don't just use the race card because it's not a card that you should just pull. So then after that, I'm talking with Leah Landry, and I'm telling her how frustrated I am about my floors not getting, taken care of. And she was like, well, people like you should stay calm, because if you don't, then you look like you're the problem. Now, me and Leah Landry have had altercations on several different occasions because Leah Landry is very disrespectful. And I'm not one to allow anyone, whether I'm renting from you or whatever, to disrespect me when I haven't done anything to be disrespected. So no, I've never reported any of those incidences. And obviously Leah hasn't reported any of those incidents because she knows she was wrong. So now comes the time for us to be moved. On July 14th at 10 o'clock, they come in, one of the maintenance men come in, the head of the maintenance comes in, he does an oxygen test with the oxygen people. Later on that day, around 1 o'clock-ish, I get a phone call from the higher ups of Auburn Housing to come and talk to me. When they come and talk to me, they inform me that I have black mold in my apartment and we have to vacate that weekend. I was the only person that was told that. I was the only person in the building that didn't have floor tiles. And I was the only person that they showed this small apartment to. I had got no notification of how long I was going to stay there, where my stuff was going to go. My service dog wouldn't fit, nothing. So then after I was like, no, I'm not moving there, we had a meeting that Monday on July 18th. No tenant was notified of that meeting except for me. Only 3 of us was allowed to get there. And it was me, another tenant, and a black gentleman who didn't speak English, who couldn't even understand anything that was happening. So then once they decided that all 6 of us have to move, they told us in the meeting that they called up Center Street and there was no hotels available. So one of the higher ups informed us that we had to move into the hotel behind Margaritas, which is a known drug and alcohol, drug addict, prostitute hotel. So I informed them that we're not moving there because I advocated for everybody in that building because they were just trying to throw us anywhere. And we've been out of our apartment since July. And here it is now, February, and we're supposed to go back in March. So if we did go to that hotel, they only had 1 bedroom. There was no kitchen. There was no amenities, no nothing for any of us to be comfortable. When you guys failed to do your job correctly and we have to be put out, we should be able to put in somewhere where we're able to live with our family comfortably. So I called the Marriott after the meeting and I talked to the Marriott to see if they had. Yeah.
I just am going to ask you not to use the names of the specific.
Oh, I'm sorry. I called the hotel. I apologize. I called another hotel and to find out they had any openings. They did have openings. I did message one of the higher ups, our contact person in Auburn Housing, and my family got here on July 20th. And we've all been here since the middle of July. During this time of me being here, the first month of me being here, I got 2 lease violations. I've been living in Auburn Housing Apartment for almost 6 years, and I've never received not 1 lease violation, not 1. I got here, and I've been the only family that received 2 lease violations. One of them was because my kids were too loud, and there was blood on the sheets. One of my kids had bloody noses. I had started my menstrual, and one of the kids picked a scab, and there was blood on the sheets. Now, if we were at home, because all the sheets at the hotel are white, if we was in our home, if you would have did your job correctly, and we was in our home, I would have never gotten neither lease violation. Another one was because I had a candle lit and I had incense burning. I wasn't aware that I wasn't able to light candles or light incense. Once I was aware, I haven't done it again. But because somebody came in, took a picture, sent it to Auburn Housing, and I didn't get that lease violation until a month after we had our human rights conference. And we've already discussed those things in that conference. And then I got another lease violation after that conference. I emailed the commissioners to let them know that I'm still being harassed because I've been harassed since I've been here. The first 4 or 5 months I was here, I was being harassed by Auburn Housing with lease violations and this and that. So I did contact Human Rights Commission about the last lease violation, and they told me that I wasn't able to submit that. I had to file a new Human Rights Commission. So with that being said, I'm not understanding how after 5 months of all this going on, that their lawyer is able to submit an affidavit that they finally, after 5 months, a week before we have court, you all of a sudden found somebody to say that Mr. Jordan did not say what he said to me. I don't believe that should have even been submitted because that was the week before we had court. That was last week that you submitted that. Now, I wasn't able to submit my lease violation that happened a couple days after our conference and investigation had started. I wasn't able to submit my evidence. So I don't understand how all of a sudden, after 5 months of this going on, you have a witness that states that Mr. Jordan did not say that to me. When all Nason men were down in the basement, they have cameras in the Auburn housing apartment complex where we live at. They don't always work. So I don't even know if they have that, but if there is cameras, they should have submitted that to show that there was a Nason man out there that can say, hey, I was here and I heard him saying, I didn't hear him say that. But all you have is an affidavit 5 months later after all this has happened. And I'm done. Thank you.
You will have 1 minute left. Fast talker. You will have 1 minute left to get back to you. But first, commissioners, any questions? Commissioner O'Brien.
Thank you. Hello. It sounds to me like Auburn Housing has to get their act together, and they really are a mess.
Yeah.
However, the fact that you are African American, how does that? I mean, it sounds as though they were. I understand the term they used or supposedly used, but in regards to all that you said, you've had some real issues. But how do you contend that it's because of race? That it's different for you?
Because I had called Auburn Housing 22 times and I had asked them for my maintenance reports. My neighbor, there was a white neighbor of mine, she had called Auburn Housing Authority about her, because she had like little pieces of floor tiles coming up. And when she called Auburn Housing, I was at her house. And when she called them, they answered the phone. They listened to her grievance. They came out, they looked at the little floor tiles and whatnot. And every time I called, she was there. They never came out. They hung up on me. And then I have asked for my maintenance reports. And none of the calls that I've called 22 times match up to any maintenance reports. When they came in, Mr. Jordan didn't give me eye contact. He never gives me eye contact. I don't even allow him into my home because I don't feel comfortable with him coming in my home. No, there's never been any other words between me and Mr. Jordan. That's because we don't interact with each other, because I don't allow him into my home because I don't feel comfortable. So I always have the maintenance manager come into my home. And then when it comes to the apartment that they showed us, they only showed the apartment to the 3 Black families. I've talked to all of my neighbors. I've seen which one the 3 white neighbors never even seen the apartment. And then when they came to me, I felt like they was trying to get me, like they felt like I was the problem, and they tried to get me out of the situation in order to make the rest of the tenants more comfortable and put me out as being, a disturbance for them, because I've called them and I've been I'm just trying to advocate for my family, and they made it seem like it was a problem. I feel like because I was Black, that they never came and looked at my floors. I sent Leah Landry the email on June 21st. And at that point, somebody should have came to see that big hole in my middle of my floor. She never sent anyone an email in a timely manner. And if she did, nobody came out to look at my floors. Now, if one of my white neighbors have called Auburn Housing on many different occasions, and they've been out there either that day or the next day. Every time I have called, and that means like when we ran out of hot water, the beginning of last year, they never came to my house. I've called about my floor tiles. Nobody's ever came to my house. I had a neighbor call just to say something ridiculous, and they came out to her house on many different occasions. Because whenever I would call 5 or 6 times, I would have my neighbor call over something ridiculous, who's a white woman, and they will come out every single time. But when I call about my floors, they're not being taken care of. I called to let them know my children were stubbing their toes. They was cutting their toes. My youngest son had allergic reaction to 5 different molds. And because we was walking on subfloor black mold. But when a white neighbor will call about something small and tedious, purposely, because we set it up, they will come out there and check it out and tell them what's going on. But I'm calling about me and my family are inhaling and ingesting black mold because we have no floor tiles. Nobody even even bats an eye. No, not even bats an eye.
Thank you.
Thank you.
Any other commissioner questions for complainant? Seeing none. Mr. Shane, we'll come back to you. You have about 1 minute left. So I'm going to do in the meantime, and we're going to go back to respondent's attorney. Respondent's attorney, Mr. Brogan, you have about almost 3.5 minutes left.
Thank you. So the commission has now had an opportunity to meet Ms. DeShane and to understand that, as she said, she is a passionate advocate for what she believes, and a passionate advocate that she was treated differently as a result of her race. But really what has been shown is anecdotal evidence of disagreement, not racism. And one of the commissioners pointed out that maybe Auburn Housing didn't deal with some of these issues as quickly or as well as they might have. Certainly that's something that we as the Housing Authority have to look into. But to call it racism, to call it based on the color of her skin instead of personality is a bridge too far. There is no evidence of racism in this case. As Ms. DeShane stated, her difficulty started when the floor started to come up. Someone came and saw it, they looked at it, they came back again. The disagreement happened because she was frustrated by what she thought was the slow nature of the response. But Auburn Housing's dealing with an emergency situation. They're trying to deal with it as best they can. And they have one resident who is completely disagreeing with it. You heard, and the investigator heard this as well, the disagreement she has had now at the hotel. She points those out, says she never had lease violations before this. Well, I don't know if that's true or not. It's not part of the record. But we do know that she had lease violations afterwards, and those lease violations came not from Auburn Housing Authority, but from the hotel itself, which has rules. And those rules were broken. And the hotel then pointed out to Auburn Housing Authority that the rules were being broken and asked that the tenant be informed not to break the rules. And when she was informed about that, it again became a pointed racist comment to her as opposed to a general and important violation of hotel rules that she needed to follow up with. So this is, as I said, a bridge too far. You cannot and you should not go around calling people racist and accusing them of racism when it is simply a disagreement. If Ms. DeShane was a white woman and had the same disagreements, this would not rise to the same level. I don't in any way want to minimize whatever difficulties Ms. DeShane has had as a woman of color in representing her family over the years or whatever is going on. But this is not, and there's not enough evidence, nor does it meet the legal standard of Doyle of all of the circumstances, including the frequency of discriminatory conduct, its severity, and whether it is physically threatening, humiliating, or a mere offensive utterance. If you take this at its worst, if you went, as we lawyers say, to a summary judgment hearing and said, this is what was said, and this is what happened, it doesn't rise to a violation of the law or discrimination. Thank you.
Any commissioner questions for the respondent's attorney? Seeing none. Thank you, Mr. Brogan. Now we come back to Mr. Shane. You have about a minute.
I don't know what to say. All I know is that I felt racially discriminated, and he keeps saying that I felt humiliated for someone to call me out of my race. You're saying it's about personality. In a situation, I was called an angry Black woman. So to my face. So that's, to me, that's race. You can't keep saying that this is not about race when everything that comes up is me being an angry Black woman, or that I was called a Black bitch. Like that, if that's not racism, I don't know what that is. If I'm being told that I'm the blame for my floors being tore up and now all of a sudden it's a housing problem. That feel like that's racism because you want to blame me for something that I didn't even do. That's racism. And then at the end of it, you find out that it's your fault, but you blame me at first and try to get me out. To me, that's racism because the other Black families don't say anything. They're not going to advocate. They don't speak up for their family. I do, and I always will. To the end, and they don't even speak English. The other two families don't even speak English, and there's no interpreter for them. So that's racism.
Mr. Shane, I'm sorry to interrupt you, but that's your time.
Yeah, I try to get it out as much as I can.
I understand. Any commissioner questions for Mr. Shane? Seeing none. Thank you to both parties for your presentations. Now we will turn to presenting the investigation. This was a case investigated by Courtney Byrne, who is out today. So lead investigator Jane O'Reilly is presenting Courtney's investigation.
Good morning, commissioners. Can everyone hear me okay? Okay, great. So I just want to start, I think in the parties' presentations, they were certainly focused on the issues that were part of the record. However, the only issue in front of the commission today is the finding on the hostile work environment. There was a no reasonable grounds finding on the terms and conditions claim made by complainant regarding maintenance issues, regarding how the issue was handled in her apartment with the water damage, on the move, and on any issues that arose while she was living at the hotel. So there was no submission or disagreement by complainant on those no reasonable grounds findings. So the submission disagreement by respondent was focused on the hostile environment claim based on the comment that the maintenance man made in reference to complainant while they were arguing. And then to sort of focus even more narrowly on that, I think in respondent's presentation, there was a little bit of sort of conflation of those issues. I want to just point out in the report, in the legal analysis, the standard for a hostile housing environment, similar to what we have in a hostile work environment, is severe or pervasive. You do not have to have sort of, while looking at those comments, you do look at the larger context, but a singular comment can rise to the level of a hostile housing environment and does not have to involve other situations in which there's evidence that a complainant was treated differently if the comment itself indicates that the housing environment is hostile towards an individual because of their race. So in this instance, the investigator found, based on the record and based on complainant's the corroborating statement by a neighbor, that the statement was made and that the insult included a racial description. Some of the examples pointed out to by respondent in their submission disagreement included offhanded comments such as that an individual was Black. That's not what occurred here. She was not being described singularly as a Black woman outside of any other context. It was a descriptor that was used as part of an insult towards her during an argument where it's true that both parties agree they were heated because of the circumstances that were going on. So I can talk more about the record and why the investigator found that comment to rise to the level of a hostile work environment. But the most important thing I think for me to focus on for you this morning is just that there is no terms and conditions claim of reasonable grounds finding by the investigator regarding, again, the maintenance issues, the transfer to the hotel, or anything else that was brought up today in the presentation. So I'm happy to answer any questions.
Commissioner questions, Commissioner Ashby.
Thank you. That presentation eliminated about 12 questions that I had. So, because I see it the way you have explained it, and there was some conflation going on about terms and conditions versus hostile environment. Assuming arguendo that the statement was in fact severe enough, the one statement was severe enough to meet this definition to create a hostile environment. And I think that the complainant, assuming that it is true when she says she was humiliated, which was also a finding of the investigator, which I think also meets a prong of that test. I'm still wrestling with the requirement that really wasn't discussed at all in the respondent's defense. The requirement that the complainant must show that the respondent knew or should have known about the conduct. What do we have in the record for evidence of that? This is Mr. Jordan, as I understand it, was an employee. I understand that a lot of the complaints about the denial terms and conditions all predated, were all things that happened prior to the statement having been made. What evidence do we have that they knew or should have known? Or I think this, the sort of second prong of that defense is that once they became aware of it, they could avoid liability by showing they took immediate and appropriate corrective action.
Correct. So what happened after the comment was made is complainant did report it. She did not receive any sort of immediate response to that report. She did follow up a couple of more times to say, I would like a complaint form. The respondents don't have a formal form. Once the report was made, respondent provided as part of the investigation that they started looking into it, and it was respondents spoke to the individuals involved who denied making the statement, as Mr. Jordan continued to deny throughout the investigation that he made the statement at all, and there was no further follow-up, redress, anything like that in the record that was addressed with Ms. DeShane regarding that comment. So she made them aware. They have not disputed that they weren't aware of it or aware of her report. What they dispute is that the statement was made at all. It's respondent's position that she's incorrect, that Daniel Jordan made the statement and called her a black bitch.
You all set, Commissioner Ashby?
I guess. I mean, I'm still no, I'm not. So I'm still wrestling then with that. So assuming all those things to be true, the respondent became aware of the complaint. It looks like your footnote, well, on page 6 of the investigator's report, not your report, but there's this discussion about the fact that the complainant asked for a specific complaint form, but none existed. And so respondent, as I understand it, had to check with their attorney, which took some time. And there was a couple-week delay where there was some question as to whether they could even provide this form. I guess footnote 9 indicates that explanation was never communicated to the complainant, but do you think it's a finding of the investigator then that the failure to subsequently discipline Mr. Jordan, or believe someone has to come forward from the respondent and say we believe Ms. DeShane in order for them to be deemed to have taken appropriate sort of remedial action after the complaint? Because beyond that, I'm not really sure how we have employer liability in this case.
Yep. So basically, the record is absent that the respondents took any action, absent asking was it said, and in determining that it wasn't. So in this case, based on the investigator's finding that there was adequate evidence that the statement was made, the respondent didn't do enough in response to the comment to ameliorate what had happened. So again, that may not be, sort of the answer you're looking for, but it's what's in the record. I mean, basically, she kept trying to communicate with them. She did eventually get a form that they say she never returned. But, she had made her report and there was no real follow-up with her regarding that report.
Well, I'm not looking for a particular answer, but I'm thinking that my view of what a sort of appropriate remedial action would be to do something to stop the hostile environment, right? And it doesn't seem like that type of comments that they were repeated, nor was there, as I understand from the record, sort of subsequent treatment of her that she could ascribe to being related to her race. We have one statement.
Correct. It's the one statement, and it was the investigator's finding that based on the context of that statement, who was making the statement, what the statement was, the fact that she was going through a very significant maintenance issue, and this was the person who was responsible for that, who made the statement that influenced sort of the general context of whether or not it met the burden of severe. And then in addition, you're right, there was no evidence in the record that respondent avoided liability by addressing the issue to the satisfaction of, making complainant feel as though the environment wasn't hostile. The statement made it hostile, and then there was no other follow-up regarding that.
Okay, thank you.
I think Commissioner David.
Assuming or it's clear that the statement is offensive and hostile, can you speak to the the pervasive requirement is the one statement fulfill that requirement of that it be pervasive?
So the standard is severe or pervasive. It does not have to be additionally pervasive.
What's the first one? Or
severe?
Severe or
So
pervasive.
severe.
It's not severe and
Yeah.
pervasive. Severe or.
So you can have a hostile environment of pervasive, not severe comments that just create over time create a hostile environment, or you can have a singular incident of a severe enough statement that makes it does not have to be an ongoing issue.
Was there any indication of any discipline of Mr. Jordan?
No. There's nothing in the record.
Is that significant to the investigator's finding?
I think it goes to the issue of whether or not the respondent could avoid liability for the hostile environment.
Say that again, please.
Jane, the audio is going in and out.
I'm so sorry. Let me switch. Is that better?
Yes.
Yeah. Sometimes I have to switch back.
Can you say that again?
Yes. The issue of whether or not he was disciplined goes to the part of the analysis of whether or not respondent can avoid liability by showing that it took immediate and appropriate corrective action. In this case, respondent appears to have taken no action in regards to its investigation.
Jane, I'm sorry, but it's still difficult for us to hear you.
I'd like to get really close to my computer and try again. How's that?
We'll see.
I will speak more slowly as well.
So I still didn't get the response. You're saying that whether there was any discipline goes to the issue of the employer's liability?
Correct. As part of a defense to a hostile environment claim, if as soon as the respondent is aware of the hostile environment, if they take appropriate and immediate action, they can avoid liability.
And they did not.
In this case, there's no evidence that they took any action other than their investigation. They didn't take any, there's no record of discipline or anything like
that. Thank you.
Any other commissioner questions about the investigation? Seeing none. Thank you, Jane. So commissioners, you've heard from the parties and about the investigation. At this point, we'll be looking for a motion or motions. There are 3 proposed findings. You may want to take them separately, but that's really within your discretion. Someone's going to have to do something. Do we really? You really do. If I could do it for you, I would.
I'll move that there are no reasonable grounds to believe that respondent Leah Landry discriminated. Elena. On the basis of race and color, and the claim should be dismissed in accordance with the act.
I'll second that one.
So it's been moved and seconded to find that respondent Leah Landry, that there's no reasonable grounds to believe that respondent Leah Landry discriminated on the basis of race or color. And is there any discussion among commissioners for that finding? Seeing none. So the motion is for no reasonable grounds regarding Leah Landry. If you are in agreement with that, we'll vote yes. Commissioner Ashby.
Yeah.
Commissioner David.
Yes.
Commissioner O'Brien.
Yeah.
Commissioner Walker.
Yes.
So regarding respondent Leah Landry, the finding is no reasonable grounds.
I'll move that there are reasonable grounds to believe that respondent Daniel Jordan discriminated against complainant on the basis of race and color, and that conciliation should be attempted in accordance with the act.
Second.
So it's been moved and seconded to find reasonable grounds to believe that respondent Daniel Jordan discriminated on the basis of race or color. Is there any discussion among commissioners?
Just briefly, I think that there is certainly more than an even chance that it would be found that this is one instance is severe enough. It's reprehensible comment, by the way, and is in fact severe enough to meet the obligation to show hostile environment. There is no requirement of a nexus between, well, except for the fact that it affects a person's enjoyment of their housing. There's no nexus to show that it affects terms and conditions, as was seemingly argued by the respondent. She was humiliated, and I believe that she was. And the fact that it was public sort of adds, it isn't a requirement, but it adds to that. So it's an easy one for me.
Any additional discussion from commissioners? So the motion is to find reasonable grounds regarding Daniel Jordan regarding race and color discrimination. If you agree with the reasonable grounds finding, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
So it's reasonable grounds for respondent Daniel Jordan. Commissioner David?
I'll move that we find there are reasonable grounds to believe that respondent housing authority discriminated.
Is there a second?
Second.
So it's been moved and seconded to find that respondent Auburn Housing Authority discriminated against complainant on the basis of race or color. Is there any discussion among commissioners?
I found it, I find it a very close case, and then because of that, I tip that, you know, how do you make that decision if it's that close? And one is that it's as equally likely or not, and therefore by that standard, you find that there are reasonable grounds. And I defer to my investigator in that close a call. I think that Commissioner Ashby's analysis is precisely correct on the second one. It's severe, and I'm educated that severity is sufficient without duration and repetition. There, somewhere in these things, we do have an exception for a single comment, but not that direct, not that racial, and the publicity of it is what makes that clear, and therefore the housing authority is responsible for that. That's the last thing that leads me to favor finding it for number one.
Any other discussion among commissioners? Seeing none, the motion is to find reasonable grounds to believe Auburn Housing Authority discriminated against complainant on the basis of race or color. If you agree, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
So the finding is reasonable grounds. The Auburn Housing Authority discriminated. So that's one, no reasonable grounds finding, and two, reasonable grounds finding. And the commission will send a letter to both parties and council confirming that. And we thank everybody for their participation today.
Next on the agenda is H 22-0200 A, B, and C. Tyler Strout versus Solterra Apartment, Avesta Housing, and an unknown resident. I'm conflicted in this case and need to recuse myself.
I believe the parties are present online, and I believe I believe the complainant is online. And so I know we have Amy Oldstein for respondent Solterra. I am not sure if someone is here for respondent Avesta.
I'm here for Avesta, Attorney John Mahalik.
Okay, so
Good morning.
I am not sure which respondent we should hear from first. Hold on.
Hear from complainant first.
We should hear, this is a no reasonable grounds. Thank you very much. This is a no reasonable grounds recommendation. So we will hear from complainant first. Is complainant Strout? Can you put your camera? You don't have to put your camera on.
Yeah, I'm here.
Okay, so if you want your camera on, you can put it on. If not, leave it off. You will have 10 minutes to present.
Okay. So I filed this complaint because as of moving into this building, I've found it nearly impossible to stay in touch with the religion I believe in, which is Religio Roma, who's represented by a community known as Nova Roma, which is a way to get in touch with their flamen, which is their term for the equivalent of a priest or priestess. And basically, prior to living here, I lived at the Comfort Inn in South Portland as part of a hotel voucher because I was homeless. And while I was there and shortly prior to that, I found a connection with the religion and found that their blessing helped me get off the street and better my life when other religions and life in general led me basically to ruin. And I spent about 8 months at the Comfort Inn praying to set up a new world and a new life for myself.
I'm sorry, can I pause you for a second? And
yes.
just ask you to not use the name of that hotel because they are not a party to this case?
Yeah, no problem.
Thank you, go ahead.
And basically I spent 8 months praying to set up a new world for myself so I could move forward in life and get out of homelessness. And when I found Avesta Housing and Solterra Apartments, I was excited to move in because if you break down the names Avesta and Solterra through Latin, which is the language invented by ancient Rome, which is the empire and city that was ruled over by the gods of Religio Roma, you'll notice that Vesta is a direct allusion to Vesta or Vesta in Latin, who's the goddess of hearth and home, and Sol Terra is a direct allusion to Sol Invictus, who is the god of the sun, and Terra, who is the earth, to Religio Roma. So basically the business that manages this building is named after the religion I believe in, and the building itself is named after the religion I believe in. But since moving in here, I have experienced an overwhelming amount of Christianity sent my way through, I believe, the residents and potentially some of the employees of Avesta Housing. And when I brought this to their attention, I was told there was nothing anyone could do about that and that they wouldn't do anything without any physical evidence. But at the same time, the people that I believe have been praying for Christianity to be forced on me and essentially stealing the blessing of Religio Roma from me, reported that I threatened to kill guests in my apartment when I didn't have any guests. The only people that have been here have been my parents, and I didn't threaten to kill them. But one of the employees for Avesta Housing, who also works for Maine Behavioral Health, she called me and said that she was told that I had threatened to kill my guests, and then she put that in writing in the report without any physical evidence, when the security cameras in the hallway will clearly show that no one's been in or out of my apartment at the time of the alleged threat. And when I spoke to other employees about my religious freedom, like I said, I was told there was nothing they could do without physical evidence, but they were willing to ask me about whether or not I threatened to kill people without any physical evidence at all whatsoever. So I believe that is a sign of discrimination based upon my religious preference. One of the employees of Avesta Housing, the landlord, she has claimed in writing that I said that I had a pastor and attended church, when I have provided emails to the Maine Human Rights Commission that state my religious affiliation directly to the landlord in writing, and broke down the same thing that I broke down for you about Avesta and Solterra and the relation to the religion. And after I said this, she claimed that I said I had a pastor, which is clearly a blatant sign of her claiming that I'm a Christian, and shows that she would be willing to send me or force Christianity upon me in my home instead of allowing me to practice the religion that I believe in. And she's the one who said she wouldn't do anything to assist me without physical evidence. She also claimed that I have ongoing mental health issues, which is a retaliation to me choosing not to go to orientation when I moved into the building, which I didn't understand because this isn't a job and I'm not in college. I'm a 30-year-old man. I've lived alone in houses, and I've lived in a different shared living environment before, and I don't need to be introduced into how to use the laundry or how to use my mail or use the internet. So I believe that their claims of me having a mental health issue when I have a therapist who has not diagnosed me with mental health issues. I've been tested for various mental health issues, and I've tested out of the attention deficit disorder, attention deficit hyperactivity disorder bracket back in 2018, I believe. And I even applied for disability in 2018, and the state of Maine denied me disability because they said I do not have any mental health issues. And the fact that Avesta Housing is claiming that I have mental health issues, they're claiming that I've threatened to kill people, and they're claiming that I'm a Christian after I've put in writing that I'm not. And after showing that there is physical evidence showing that I've never had a guest that was threatened. The only people that have been here are my parents. And I just spoke to my mom 20 minutes ago, and my dad was in the parking lot yesterday. Like, if I threatened to kill them, they wouldn't be speaking to me. They both kicked me out of the house at one point in time in my younger years. So they would be willing to cut off ties if I actually threatened to kill them. But these like slanderous and defamatory claims against me about my statements, my mental health, and my religious affiliation, I believe, show a direct line of discrimination against me for what I believe in. I've also received multiple lease violations for noise complaints because I play guitar, but I have not been given an exact decibel level to play at or beneath to set a scientific standard for me to be compared to when someone complains about me. And once again, within Religio Roma, which is a polytheistic belief system, Apollo Medicus is the god of music. And Apollo Medicus blesses me to play music. It is part of my duty within the religion to be a musician. My guitar is what I am with still through all the years that I've had this guitar. That's all that I have my family and I have my instrument. And the god Apollo has blessed me with music. And I've been discriminated against for expressing myself freely as an American and as a member of Religio Roma through performing music in my apartment at a decibel level that is not much higher than what would be experienced in a restaurant or a bar. I actually went to a restaurant and sat outside of the restaurant and spoke with someone with my decibel meter on the phone, and it was very close. It was at the average of what my guitar is and just beneath the maximum decibel level that I've recorded playing in my room. And the people here have claimed that I'm too loud. They've discriminated against me. I've gotten lease violations from Avesta Housing for these issues when they refuse to write, to my knowledge, refuse to write lease violations for people selling drugs in the building, for people smoking in front of the doorways within 20 feet, which is a lease violation, for people having dogs in the building, for people being loud after quiet hours. I'm not loud after quiet hours. I don't force my religion on anyone. I don't bother anybody. And these slanderous and defamatory statements and the infringement on my religious freedom has affected me in a negative way when it comes to transitioning back into normal life after spending the entire pandemic living out of a car and a backpack. And I believe that Avesta Housing's lack of desire and their utter unwillingness to look into the issue related to me being able to practice my religion is a direct showing of their willingness to discriminate against me, the employees in particular, not necessarily the owner of the business or whoever owns the building, but I believe that the employees are discriminating against me and slandering me and are trying to evict me. Yes.
Mr. Stroud, I'm sorry to interrupt you, but that is your 10 minutes.
Okay.
So I'm gonna check and see if any commissioners have questions for you. Commissioners, any questions for Mr. Stroud? I do not see any, so thank you, Mr. Stroud. I'm gonna mute you while we hear from respondent, okay?
Okay.
So we have two respondents here who are separately represented. So I'm going to turn first to Solterra since they're named first. And I'm going to ask both respondents counsel to try, if possible, to use less than 10 minutes so we can try to keep this as brief as possible. Ms. Philippines.
Yes, thank you very much. I'll be incredibly brief. Solterra owns the property that is managed by Avesta Housing in Bayside. As is reported in the investigators' findings, Solterra, which is affiliated with Portland Housing Authority, had no contact with Mr. Strout directly, nor did it have any communications with Avesta about Mr. Strout or his alleged complaints regarding religious discrimination. For those reasons, in addition to the fact that there's, based on the facts that have been outlined in the report, there's no basis for a finding of religious discrimination here on the part of any of the three named parties. One thing I do want to just clarify is that Mr. Strout, while he was speaking, referenced several times potential disability issues or disability discrimination that he may have experienced. And I just want to confirm that those were never raised in his original complaint. The only issue here today is whether or not he was discriminated based on religious grounds. And I'll end there. Thank you.
Thank you. Any commissioner questions for Solterra Apartments? Not seeing any. So then we'll turn to Mr. And I'm probably going to butcher this as well, Mr. Michalek. Michalek.
Thank you. It's Mihalik. Yes.
Thank you. Sorry.
That's okay. Good morning. Yeah, this complaint is based on religious discrimination only, and as I understand it, the two primary allegations are that by Mr. Strout or that my client is somehow stealing Roman blessings from him, and that we're somehow involved in placing hallucinogenic drugs in a clothes dryer. My client denies both of these claims. Nothing my client does is in any way influenced by whatever religion Mr. Strout chooses to practice. Mr. Strout, my client respects the fact that their tenants can practice different religions, and my client, doesn't act or enforce their lease in a way that has any bearing whatsoever on the religion of any particular tenant. My client engages in uniform lease enforcement across the board. Does not really understand the nature of the complainant's allegations in his complaint. But I think that the investigator in this case appropriately found that there's no reasonable grounds for a finding of discrimination, religious discrimination, and as a result, it asked that the complaint be dismissed.
Thank you. Any commissioner questions for Avesta Housing? Seeing none. Thank you very much.
Thank you.
Since complainant has used all of their time and respondents have completed their presentations, at this time we turn to the investigator, and this is the case that Kit investigated. So you're there.
I'll be very brief. I have nothing further to add. I'm happy to answer any questions.
I have a procedural question for you or Barbara, but you're both lawyers. I've never seen three before. How do we have an allegation against an unknown resident?
Against an unknown resident. Complainant amended his complaint about 3 months into the investigation and provided that somebody in his building, he provided an address. We sent the notification packet to that address. They never participated, but nonetheless, I did not find reasonable grounds that anybody had discriminated against them. Yes. Sometimes that happens. People don't know the names, that they have contact information somehow, and so we try.
Yeah, we could not know the name and still find something or find some nexus in another situation. Okay, thank you.
Thanks.
So you commissioners, you have heard from the parties and from the investigator. There are 3 proposed findings here, which you can take separately or together.
I'll move to take them together and that we find there's no reasonable grounds to believe that respondent Solterra, Avesta, or the unknown resident engaged in unlawful discrimination on the basis of religion and prejudice.
Is there a second? So it's been moved and seconded to find no reasonable grounds to believe that Solterra, Avesta, or an unknown resident subjected Tyler Stroud to discrimination. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds against all three respondents. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the findings that are all no reasonable grounds to believe that unlawful discrimination occurred. And the commission will send parties and council a letter confirming that. We thank you all for participating today.
We have 2 more in the morning.
I loaded up heavy in the morning.
Yes.
Yeah.
Can we just take 2? It doesn't even have to be 10.
Yeah.
Of course.
Okay, how about if we take a quick break and we'll be back in 2 minutes?
Yep.
Is this muted now?
And we gotta get Tom back too.
Douglas.
All right. We have
There he is, TLD's back.
All right, next on the agenda is E 21-0290. That is Zachary Lavalle versus Bath Ironworks Corporation. This is a no reasonable grounds case. We're looking for the complainant or his representative.
I see Mr. Silver for respondent. I don't know if complainant is one of the folks on the call. Is that you, Motorola Moto? Is that you?
Yes.
Okay. And I would mention we have investigator Angela Morris. This is her first presentation to you. Mr. Lavalle, we'll hear from you first. You have 10 minutes, and I just remind you not to use the names of any third parties, people who aren't named as a respondent, okay?
Okay.
All right, go ahead, you have 10 minutes.
Hi, my name is Zach Lavalle. I'm a former employee of Bath Ironworks. I was hired back in April of 2013. I was let go back in September of 2018. Guys, I'm losing where I'm going with this. Sorry. The reason why I'm here is because of a discrimination and quite possibly, more reasonably, a retaliation on Bath Ironworks' part. Is I went to a drive-in interview. BIW was doing those events where, at the time, were offering jobs on the spot. You know, at the interviews, they had foremans from different trades, and they were popping up all over the place. They had it on the radio, they had it on the news, they had it on Facebook, pretty much saying, "Hey, you can get hired on the spot," yada yada. Well, I end up going to the one in, I can't remember the location. I bet you guys have it on file there. But when I did go there, I was in fact offered a position with a wage and a shift, and told that I would be notified within a few weeks after my background check came back. I was given a piece of paper with a login, a step-by-step procedure, how to apply to accept the job offer. I filled that out like 2 days later, I think it was. And weeks went by, didn't hear nothing, so I called in. They didn't even know I even applied. They denied that I, even submitted an application. They're saying, and then they actually no, they never even said that. They stated that they weren't taking me back on the grounds of me being terminated. It wasn't until later when this case started that they started bringing up the whole, well, you didn't apply, and then they started bringing up my previous cases with them. One of the biggest deals with this is why it's an issue is because there was an agreement in the last litigation I had with Bath Ironworks that if I were ever to be offered a position, that I would be able to go back without having past transgressions being used against me in decision making, and that they would not be able to just flat out refuse me. They already offered me the job. They offer me the job, and then they go ahead and they say nope, not going to do it right there at the HR there. So I'm losing my train of thought of what I was going to say. Sorry. The issue is BIW is not truthful about any matter. I read the reports. You guys stated that they're credible. I tried to inform you that that is not the case. I have 2 winning litigations against them. Will inform you that these people are very manipulative, and they will twist and tell you lies until they're blue in the face. I've been dealing with this for a while. Probably asked why I want to go back there. Well, because My whole family's been there for generations, 8 generations. In fact, I love that job. I enjoyed doing the work. There were, this, other than the politics of it, it's a great place, great benefits, good pay. I can't get that anywhere else around here. And I feel like I'm being, excluded from the opportunities that Bath Iron Works keeps reminding me every time I'm driving down the road in my truck, and I have to listen to the radio about how they're the best employer in the state and they have this, this, and that. I'm like, yeah, well, I don't get that opportunity now, do I? And there's no reason for it. They have been telling you guys that I was terminated for job abandonment. Well, originally that was the case, but under litigations that I won, that's not the case. And the fact that in the agreement, they're not even supposed to be discussing those cases with you. So the fact that they're trying to use 2 litigations against me in their decision-making to rehire me is a clear indication of retaliation and discrimination against me. They tried informing you guys I never submitted the application. Well, I submitted the application. They tried denying that they never offered me a job. You have a form there somewhere in front of you saying that they did in fact offer me the job, but they scratched it out. BIW also tried to indicate that they had no right to hire me on the spot. Well, first off, they made that very clearly all over social media that they were in fact doing that. And if they weren't doing that, why was there even a form in the first place saying that they did in fact offer me the job? If they had no right to offer me a job on the spot, why did I even have the form? So what I'm getting at is BIW probably didn't, the guy who hired me offered me the job based on my experience, and he knew me from past work history. When BIW got the notification, my name across their desk, they didn't want me. So it's a clear indication that they have an issue with me and they don't want me back. And they've been throwing mud at the wall, trying to find any excuse not to honor the job offer, which they in fact given me. So I don't know. So I guess it would be better if I had like questions. I can probably explain more in detail on things, but for the most part, yeah, I want to go back. I love the job. There's no reason for them to deny me. They obviously have admitted that I am qualified for the job, and the fact, I have proof that I not only got offered the job, I also submitted the application in a timely manner. They're obviously, the only thing they're holding against me is the fact that they're upset with me because I won 2 litigations against them. So unless they can give some.
I'm sorry, Mr. LaValle, I'm sorry to interrupt you, but I'm hearing from the investigator that other litigation you may or may not have against BIW is not in the record.
They don't have you don't have the records of past litigation?
I'm going to ask you not to mention that because it's not in the record of this case.
I didn't mention specifically what the litigations are about. I'm just stating that, well, actually it is referenced there because they're telling you guys how I was terminated. That's in reference to the litigations.
So
you can't say I was fired for job abandonment if I have a litigation that was a reference to that. You understand? So a lot of the stuff they're using against me to claim that I'm not qualified to go back is protected under my litigations.
And I'm telling you that I'm sorry, what I'm hearing from the investigator is whether or not you prevailed in that litigation is not in the record.
It's not.
That is what the investigator is telling me. So please refrain from mentioning that.
So they did not, they never even submitted those.
I'm telling you, it's not in the record that the investigator reviewed in this case. You still have 2.5 minutes left, and you can continue to use that or hold on to that time to use it after respondents.
Hold on to the time, I suppose.
Okay. Before we go to respondent, I'll ask if any commissioners have questions at this time for Mr. LaValle. And I don't see any just yet. So we'll come back to you, Mr. LaValle. I'm going to mute you in the meantime, okay?
Okay.
And right now we'll turn to BIW, and I believe that's Mr. Silver.
Yes, good morning, commissioners. My name's Steve Silver. I'm an attorney at Littler Mendelson, and I have the privilege of appearing today on behalf of Bath Iron Works, or BIW. Investigator Morse did a good job summarizing complainant's prior work history at BIW and why a no reasonable grounds finding is warranted here, so I'm not going to repeat all of that. However, I want to address some of what complainant just raised. First, about this notion of litigation. There's never been prior litigation. That's why it's not in the record. There was a union arbitration that involved a 2017 last chance agreement violation. That's really not relevant here because the complaint in front of you is about a 2020 alleged job offer. So I don't know what litigation he's referring to or any successful wins. It just doesn't exist. But let's focus on the complaint in front of you, which is that on September 18th, 2020, allegedly BIW offered Mr. LaValle a job and then retracted it because an unidentified person, never been identified, told him he could not be rehired. That's just false. Not only is it false, but the investigation actually proved that it's false. The facts came out, right? Number one, that he didn't receive an offer of employment on September 18th, 2020, or any time in 2020 for that matter, right? These drive-through events, and the one in question was in Oxford. Candidates or applicants can complete a trade questionnaire. They get a quick, 5 to 15 minute interview. If BIW thinks that they're qualified, they certainly can offer a job. But anyone who's qualified, they give them instructions on how to apply. It's Exhibit 10. And so there's a list of things to do to go online and fill out the application. That's what he was given. That's what you heard from complainant today. He was given. Now, why be given instructions to apply if you got this job offer? All potential candidates get that. It's not unique to him. He did apply. He did go online later and applied. But that doesn't mean you got a job. You have to then interview. And the instructions say that. In fact, he went to a second drive-through recruiting event in Brunswick the next month, which would seem odd if you had a job offer in hand. He didn't receive an offer at that event. However, with his pending application, there is a really simple way to move forward in the process. Now, complainant told you how great it is to work at BIW, and I certainly agree. Sitting here today, he's eligible for rehire. But what the senior personnel record specialist, right, the woman who's worked for BIW for nearly 4 decades, credibly testified and told the complainant not once, but twice, that to complete your application, you need to write, whether it's an email, a handwritten letter, a typed letter, whatever it is, addressing your termination, what you've done since then, your work history since then, what you're going to improve, particularly in this case, where the last chance agreement involved workplace violence. Okay, that's an agreement that the union and complainant agreed to, that he should have been discharged at the time. All he has to do is submit that letter. It goes to the VP of HR. This is the policy for every single rehire of a terminated employee. It is not unique to complainant. He could do that today if he wanted to. He could have done it in 2020. He refused twice. So once he refused, the application didn't go anywhere. There never was an offer extended, and it certainly wasn't extended and revoked. BIW obviously has a very real reason for requiring terminated employees to do this. It's been their policy for many, many years. It's not unique to him. It's applied to all. And in this case, with complainant, which is Exhibit 7 in your packet, his tenure that ended in 2018 hit 15 disciplinary actions in 3 years, including multiple instances of workplace violence. So even if he writes the letter and gets through, I can't guarantee he's going to get rehired. There's certainly no duty to rehire somebody. And this agreement that he mentions, which is exhibit, let's see. Pull it up here. Exhibit 8 in your packet. When you look at eligibility for rehire, right? It says BIW agrees he won't be prevented for applying. And however, BIW is under no obligation to hire Lavallee. He will not be prohibited from hiring consideration. He's never been prohibited from that consideration, but he's not guaranteed rehire. He has to be qualified and complete the application steps. BIW also agreed it will not provide a negative reference. Obviously, that's pretty standard. It never did. But all the other terms he tried to tell you don't exist. It's not in there. So, if BIW is the place Mr. Lavallee wants to work, certainly welcome his application. My understanding is he has applied more recently, but still has not completed the process that has been communicated to him on multiple occasions to move forward with his candidacy. Thank you.
Thank you. Any commissioner questions for Mr. Silver at this time? Seeing none, thank you. We'll turn back to Mr. Lavallee. Yep, hold on. Mr. Lavallee, you have about 2.5 minutes.
Well, he just read off about able to come back to work and all that. That was in reference to the litigation, and I'm quite dumbfounded how they could know about that but still claim that there was no litigation. The union portion from the second time around was in reference to the first incident of being accused of my workplace violence. Wasn't long after I was strong-armed into signing such agreement. No more than a couple months into being back to work, the company pursued to try to terminate me wrongfully, accusing me of a workplace incident that never took place, only proving the show that I was being set up from the get-go. Again, I don't have any legal counsel to better explain to me what I can or cannot be saying on the matter. It's kind of why I'm trying to go through this procedure so I can get to the next step here. But there has been legal steps in place, whether with the union or with my attorney, on 2 different matters concerning these incidences that BIW is trying to hold over my head as far as being eligible for rehire. As I stated before, my lawyer, I called him and I told him what I was informed by by the lady at BIW. He informed me that to sign that would not be in my best interest. And I also have yet to receive anything where it's, mandated. I mean, regardless whether or not BIW, has done it and had people write things out, I get that. But I have not yet seen anywhere there's a law or rule of any sort that is, required to be able to go back to work. And I still have not seen how that applies to somebody that, and under my situation, where I was neither, left on my own, nor was I terminated because, again, there was a litigation that, dealt with that. So therefore, I'm kind of like in limbo, as you would.
So, Mr. Lavallee, I'm going to ask you, let you know that is your 2.5 minutes. So let me just see if any commissioners have questions. Any commissioner questions for Mr. Lavallee? Seeing none. Thank you, Mr. Lavallee. We're going to turn to Mr. Silver. Mr. Silver, you have 4 minutes left.
Thanks. Again, there was a union arbitration. I think maybe that's part of what is being referenced here. I'll let Investigator Morse present her report, but complainant is eligible for rehire. There is actually a code that would be in the system when those are not eligible. He is eligible. They received an application, communicated to him on multiple instances what he needed to do. He's refused to do it. There's nothing else BIW can do. There is no duty to rehire. He was never guaranteed employment. And when you just look at the complaint alleges whistleblower retaliation, which we've never heard anything about today, because there was none. He wasn't working at BIW at the time. But even if you extrapolate that to some MHRA retaliation, there wasn't a job offer. It wasn't revoked. He's eligible for rehire. He can go apply for a job today. And if he wants to complete the application process, based on what he's testified to, he's probably qualified. But you've got to complete the process. Thank you.
Any commissioner questions for BIW? Seeing none. Thank you. And then we'll turn to investigator Angela Morse.
Hi there, I'm Angela Morse. I'm the investigator assigned to this case. To me, this all boiled down to the fact that there was no adverse employment action because the complainant did not establish a prima facie case because the application process was not completed. That letter was not drafted addressing past transgressions. This was a uniform requirement, not unique to complainant. And at this point, the complainant has not fulfilled the application process.
Thank you. Commissioner questions for the investigator? Commissioner David?
Angela, it's vague, but as I understand him, he's saying that he couldn't write the letter because of some confidentiality requirement. Do you find anything to that claim?
I'm not privy to, the ins and outs of the agreement that was reached. But this is a uniform requirement. The specialist who has been at BIW for several decades credibly testified at the Issues and Resolution Conference that this is a uniform requirement for employees that have been discharged. So, this has not been completed.
Was she asked that question at the conference?
Yes, she was present at the Issues and Resolution Conference, and she did testify that that was a standard requirement. And she did convey to the complainant that that is a requirement on more than one occasion.
Thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Angela. So commissioners, you've heard from the parties and the investigator. At this time, we'll be looking for a motion or motions. There is, no, just one motion. There is one proposed finding.
I'm a little bit of find there's no reasonable grounds to believe the respondent retaliated for engaging in any human rights act protected activity, and the complaint should be dismissed.
Is there a second? So it's been moved and seconded to find that there are no reasonable grounds to believe that unlawful discrimination occurred. That no reasonable grounds to believe that BIW retaliated against Zachary LaValle for engaging in MHRA activity. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you vote yes, you're in agreement. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yeah.
So the finding is no reasonable grounds to believe that unlawful retaliation occurred. The commission will send parties and counsel a letter confirming that, and thank you for participating today.
Next on the agenda is E21-0404, John Davis versus Penobscot County Commissioners. This is a no reasonable ground case. As a result, we should hear from complainant or complainant's representative.
I believe we have respondents counsel here. The question is whether complainant is present online. Mr. Davis, if you are here, can you let us know? There are a couple of phone calls on here that don't have identifying information. So, Mr. Davis, if you are one of those folks, now is the time to unmute or send me a message in the chat and let us know, because otherwise I'm going to conclude that Mr. Davis is not present. Last call for John Davis in E210404. I do not see that complainant is present. And commissioners, typically when the party opposing the proposed finding does not appear for hearing, the commissioners vote to adopt the recommended finding.
I'll move that I'll take both findings at once. That there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of age and or disability, or that they retaliated against complainant on the basis of engaging in act protected activity, and that the complaint should be dismissed in accordance with the act.
Second.
Hold on just a second, please. It's been moved and seconded to find no reasonable grounds to on both claims. Is there any discussion among commissioners? Seeing none. So the motion is find no reasonable grounds on both age and disability or retaliation. If you agree, you will vote yes. Commissioner Ashby?
Yes.
Mr. David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yeah.
Mr. Walker?
Yes.
So the findings are no reasonable grounds, and the commission will let council and the parties know that in writing. Thank you. I'm going to go take this call, which I'm pretty sure is your lunch. And Barbara will, thank you to the timer, Barbara.
Our last case of the morning session is E210439, Jason Dubé versus Woodland Pulp LLC. This also is a no reasonable grounds case, so we should hear from the complainant or his representative.
Good morning, commissioners. This is Marshall Tinkle for Mr. Dubé.
Okay, so Mr. Tinkerbeck, I'm back. Just like that, I'm in two places at once. Tinkle, you will have 10 minutes.
Thank you. The investigator correctly found that when Mr. Dubé pointed out deficiencies in the employer's training program, which were related to safety, he engaged in protected activity under the Maine Whistleblower Protection Act. The investigator refused to find reasonable grounds solely based on her conclusion that Mr. Dubé had failed to show a causal connection between the protected activity and his demotion. And we think that there was ample grounds for that finding, that we did show probable cause. There was credible evidence that Mr. Dubé had expressed his concerns to the insurance auditor in the spring of 2018, and the auditor incorporated those concerns in his report to the company. So the company found out about that, and within a week of this, the complainant's supervisor called him into his office and asked if he had spoken to the insurance representative. Mr. Dubé affirmed that he had spoken out about the training deficiencies, and that made the supervisor visibly, palpably angry with him. And shortly after that, the employer began discriminating against him and began harassing him. And though it took a while for the respondent to demote him to a menial low-pay position, which it eventually did, this was the culmination of a long series of adverse actions and acts of harassment. The employer began harassing him and watching over everything he was doing shortly after the meeting with the supervisor. The harassment was severe enough that Mr. Dubé reported it to his union. Shortly after that, Mr. Dubé was called to a meeting at which he was falsely accused of not following proper procedure in his employment. Then on July 2nd, 2018, when Mr. Dubé was the field operator, the electricians wanted to work on one of the turbines. Mr. Dubé was then told that they had to do the routine turbine test on all the days that he worked. Dubé found out that none of the other operators had to do this except for him. Management also arranged the work schedules to have a disparate impact on Mr. Dubé. In 2019, management called him to another meeting and provided a handout criticizing him for events that had happened within the past 2 years. He had never previously received any complaints regarding these matters. In fact, the criticisms were unwarranted. Throughout 2019, a coworker was given preference on job assignments and training, even though Mr. Dubé had seniority over that coworker. Effectively, Mr. Dubé was passed over for a promotion that he was due. Management refused to let Mr. Dubé train for the next level position. And then coming to the crux of what happened, in May 2020, he was given a test on the turbines that was administered by the same supervisor that was clearly out to get him. And this test was not a written test. It was not an objective, fact-based test. Rather, it was a very open-ended, I'm going to ask you questions like, what if this happened? What would you do if? And then he decided, this person who was out to get him, whether he had satisfactorily answered the test or not. Mr. Dubé knew the material to the extent that he had been given training, but the test was not objective, and his supervisors used unique criteria in order to say he failed the test. He was not provided with test grades. Mr. Dubé had been working for the employer for approximately 7 years. He'd been steadily climbing the company ladder. He had shown himself to be capable, competent, and intelligent. At the hearing, the employer's representatives admitted that he was intelligent, a good worker. Before the spring of 2018, he had passed all the tests he was given with flying colors. He would have done the same in 2020 if he had been given a neutral test that was fairly administered. So they just decided that he hadn't passed this oral test. And then in March of 2021, he was given a second test, and that was also administered by the same superintendent that had it in for him, along with a colleague. Mr. Dubé was informed again that he was not going to be passed. Again, he was not provided with test grades. They make a point of saying that he was the only employee to fail the test twice. So you have to ask, why was that? Why was this person who was intelligent, who was motivated, who had passed all his other tests, why couldn't he pass these non-objective oral tests? And I submit that the clear inference was that the test was not fairly administered. It was done in a way to make him fail the test. He was preordained to fail these tests. And once he failed the tests, he was demoted to the yard crew as a menial laborer, basically, about on the scale of a janitor. And they say that they had no choice. This was either up or out. You can't just stay in the same position. But Mr. Dubé presented evidence that a coworker had been allowed to stay in the same position, had been frozen, so to speak, And that wasn't an opportunity that Mr. Dubé was given. They say conveniently that he couldn't stay in his position where he'd been working and doing very well. And they say they had to demote him to this menial position. And that simply isn't true. So based on all this, we would strongly suggest that there are reasonable grounds to believe that discrimination had occurred, and ask the commission to make a finding of probable cause. Thank you. I'm happy to take questions.
Thank you. Any commissioner questions for Attorney Tinkle? Commissioner Bryan?
Yeah, thank you. Mr. Dubé is asserting that he did not receive enough training for their tests. What would you say? I mean, 4,000 hours, and then over 6,000 hours. And I would like to know, is the test, was it unique to him, or is it a standard? I guess I understand it's subjective, but is it a standard questions for everyone else?
No, it wasn't a standard test. It wasn't the same questions that other employees were asked when they were being tested.
Okay, thank you. Any other commissioner questions for Attorney Tinkle? Seeing none, Mr. Tinkle, you'll have about 2.25 minutes when we come back to you.
Thank you.
And I believe Mr. Muzzy is here for respondent.
Yes, thank you.
Good morning, Commissioners. Thank you. My name is Daniel Mezzi. I represent the respondent Woodland Pope LLC in this matter. I have with me here today Mr. Jason Warden. He's production supervisor at the plant. Mr. Warden was also individual responsible for making the ultimate decision here to transfer Mr. Dubé out of the position he's in into a different one at the mill. Mr. Dubé was transferred out of his position in the steam plant at the Woodland Pulp Mill in Baileyville for he presented a danger in that job to himself, to his co-workers, to the mill, and also the 300 employees that are under the supervision of my client in that location. Second, he failed the qualifier tests in order to move up the ranks. The investigator did a good job describing how that works, but they have a line of progression, so-called. You move from one position to the next, to the next, to the next. He was trying to move up to the next, to the highest top position at the steam plant. Now, the reason they have these qualifier tests is you want to make sure that you have the ability and the wherewithal to do this job. Now, I don't know how many of you have been inside the guts of one of these plants, but I will say that the steam plant at a production facility like this is a multi-story building within a side of a building, boilers, valves, heat, gas, fire, and the likes. It has a blast radius bigger than this building. It's a dangerous place. It's the belly of the beast in the mill. It's where all the power is generated to run the rest of the mill. And it's important that the people that work there at the higher levels have the ability to think on their feet, to be critical when things start to go south, because this valve has to get turned, this has to happen, this has to happen. And you don't want to bring the mill down. That would be, of course, a problem economically, but you don't want to injure anybody, including Mr. Dubé or his co-workers. Or if you've been to a town like Baileyville, you'll see the importance of the mill to as the economic engine for the entire community. We've seen these sorts of problems with the Androscoggin Mill in Jamie, which had a digester boiler blow. If you have an explosion in this area, it's $100 million piece of equipment that needs to be rebuilt. That mill could never rebuild. So I don't want to be, it's not hyperbole to say that you have to be quick on your feet on your job. And just Mr. Dubé was not that person. We can't all be the top gun, the fire in a pilot situation. You can't all be a prima ballerina. You can't all be the quarterback calling audibles on the line. If you don't have that ability to think on your feet quickly, know where all the processes are, then you should not be in that position. Now, I want to talk briefly about the tests. The tests that were given, the qualifier tests here are oral-based tests. They're scenario-based tests, and they are designed specifically to become an indicator of how you would perform on the job. The reason that they do it that way, of course, they're not going to ask everybody the same question because then anybody would know what the answer to the test is. They want to present scenarios to you to make sure you understand which end is the black liquor coming in, which end is if I turn the pressure valve here, what's going to happen. Mr. Dubé failed these tests and he failed them badly. He failed them once, he failed them twice. Failing the second test was the straw that really broke the camel's back here. No one has ever failed 2 tests. These tests were administered by 2 supervisors, not just one, as counsel describes. They took turns answering tests from a long list of outline questions that are used specifically for the training for the employee. So they have a 7 page list of topic areas, and they take turns asking questions. What would you, that's correct. What would you do if this happened? Describe this, describe how this process works, describe the environmental impact if this happens. Mr. Dubé failed to pass these tests and failed to also show some of the very basic understandings that were necessary in this job and for things that he should have known during the time that he was there. He was given a chance to have training after taking the first test. But let me back up. He did have 4,000 hours worth of training over his tenure. After the first 2018 meeting that's alluded to, he had over 2,000 hours of on-the-job training for the specific job that he was applying for. This was 500 hours more than the next candidate who passed the test on the first time through. It was 1,000 more than everybody else had by average to pass this test. So he just didn't show that he had the goods in order to pass it. The second test was given by one of the same individuals, but also a second colleague. They did take turns asking the questions. And they both agreed that Mr. Dubé just really failed the test. I think one of the statements made by one of the supervisors who was involved in the second test and who is also a trainer at the mill, and this is in documentation submitted into the record by Mr. Dubé. The supervisor says, "I cannot think of one operator during this period who has not complained to me about one or more of the following." It's talking about Mr. Dubé. His lack of knowledge, his inability in upset conditions, safety concerns for him or the crew, and the general inability to train him or to be trained by him. I know these complaints have reached the other supervisors as well. The safety of Dubé, his coworkers, and 300 other employees would be at risk by keeping him in the steam plant. The idea was to move him to another facility that would meet his skills better. He didn't think well on his feet, but we do acknowledge he was a smart individual. He's very good at memorizing things, and he did well on true false tests and multiple choice tests. That's why he was offered a job in the HVAC department, but he refused to even consider that. Management tried to work with him and tried to give him a position that thought would be better suited to his skills, but he refused. In the end, certainly there's no evidence here that his reassignment was pretextual based on any speaking to an insurance auditor 3 years before this. And there's certainly no evidence that that was a but-for cause of reassigning Mr. Dubé. So we respectfully submit that you vote to find that there have been no reasonable grounds to believe that Woodland Poll discriminated in this case.
Thank you. Commissioner questions for Respondents Council? Seeing none, thank you. Oh, I'm sorry, Commissioner sorry, I missed you, Commissioner.
Yes. Good morning, Dan. Can you hear me?
Yes, I can. Good morning, Mr. Douglas.
Yeah, good. So Attorney Tinkle, the investigator's report basically says that, you know, there's a temporal problem with Mr. Dubé's claim, and then there's the fact that there were legitimate reasons to put him where he was, right, to demote him. On the temporal piece, Attorney Tinkle says, you know, in this interim, in this 3-year period, there was a pattern of discrimination ongoing. I just wanted to get your response to that.
Yes, thank you. There was not a pattern of discrimination against Mr. Dubé. Mr. Dubé spoke with an insurance auditor in March of 2018, and he spoke with that auditor because the supervisor that has been described as out to get him asked Mr. Dubé to take him out to the mill to escort this person out there. During that audit, Mr. Dubé failed to demonstrate proficiency in how to operate the equipment. And there are also allegations that you heard that he then also made a complaint to the auditor about the training. After that, and it's in our exhibits as exhibit number 6, there are a long list of problems with Mr. Dubé and his performance on the job that were observed by a number of folks firsthand. He didn't know where things were. He didn't know how things work. He had to call, ask people for additional information in order to find out where he was going. So this meeting that they say was retaliatory was a meeting that was called with Mr. Dubé and union representatives to figure out what could we do to help Mr. Dubé move forward. This wasn't some sort of an ambush, and it wasn't discipline under the union or anything. It was a let's get together, figure out what the problems are here, and they presented a list of items that they had noticed with Mr. Dubé's skills and what to do to improve them. After that, we went into a longer period of training. And yes, he had training. Everyone had training. To the extent that there were tests that were observed, everyone had opportunities to look how the equipment, the turbines were being tested. This was not a singling out of Mr. Dubé by any stretch. He had another meeting in 2019, which they say he was called in, but this was to follow up again to try to come up with a good solution for what to do with helping Mr. Dubé improve his skills. He was given a list of items and performance issues at that time because they were asked by the union to bring that forward. There was a great amount of pushback by the union to say, Mr. Dubé doesn't need any more training. He's doing just fine. But that's not what we were seeing on the ground, what they were seeing on the ground, what his coworkers were seeing on the ground. So as far as the tests themselves, the tests were not retaliatory, that everyone got the same type of a test. Of course, not everyone got the same test because you would know what the answers were. So the fact of the way the tests were arranged was actually objective, fair, and best suited to be able to indicate his performance.
All right, thanks, Dan. Appreciate it.
Sure.
Any other commissioner questions for Response Council? Seeing none, thank you, Mr. Love. We'll have about a minute when we come back. At this time, we would turn back to Mr. Tinkle. You have about 2 minutes left. You are currently muted, though.
Thank you. You can hear me now, right?
And yep.
There is no evidence other than the employers say so that Mr. Dubé was a danger to anyone at any time. If he was so dangerous, where are his counselings? Where are his warnings? Where are reprimands before he engaged in protected activity? And there just are none. After they found out about his protected activity, they started to paper his file to make it appear so that their lawyer could make an argument with a straight face that this just isn't an employee that can do his job. But that just isn't true. There's what I take to be an admission that this was a subjective test. And courts have said consistently, again and again, that when a subjective test is administered and is used as the basis for an adverse action, a fact finder can't assume that it was indicative of the employee's actual performance, but may infer that it was part of a pretext for that adverse action. That's what happened here. There are some specific questions that have been raised about Mr. Dubé's performance. He's here this morning, and I know that he'd be happy to answer any questions. You can hear from his own mouth how he did and why he was discriminated against. So either of us are happy to take questions right now.
Thank you. Any commissioner questions for complainant or his counsel? Noting that we don't typically take testimony stage. Seeing none. Thank you, Attorney Tinkle. We return back to Mr. Nuzzi. You have about a minute left.
Thank you.
Thank you. Just would like to address one item. Attorney Tinkle raises the issue, if he was such a danger, why wasn't he terminated sooner? We're operating in a union environment, and the mill wants to work with everybody to also help them move forward. And the fact that he wasn't let go sooner, or wasn't demoted sooner, or wasn't reprimanded sooner, shouldn't become the deed that for which no one gets unpunished. They came forward with, let's work with him, let's work on training, let's do some more training with you. And they refused, Mr. Dubé refused to acknowledge that he could use additional training in his current position. So we worked forward, the mill worked forward, gave him additional training, but when it came very clear that it wasn't working and things were not improving, the ultimate decision was made to not to discipline him and not to terminate him, but to offer him another job, assign him to another job in the mill, assign him to the HVAC position, which he flatly refused to even meet with the supervisor there. Thank you.
Any commissioner questions for Mr. Nuzzi? Seeing none. Thank you to both counsel. Next, we will hear from an investigator, Angela Morse.
Hi, I'm Angela Morse. I was assigned to this case. I recommended a no reasonable grounds finding because I didn't identify a causal link between the conversation with the inspector and the adverse employment action. I think it's important to note that the conversation with the inspector occurred over 3 years prior to the complainant's demotion. And also, there were significant performance issues. One I just wanted to point out occurred in 2019 when the complainant failed to follow lockout tagout procedures while manually cleaning a giant fan. So that could have resulted, if somebody was in there cleaning the fan and another employee started up that fan, that would have certainly led to, employee fatality. So there was some real serious performance issues in addition to failing the 2 qualifier tests. So I certainly would not consider that, papering the file.
Thank you, Angela. Any commissioner questions for the investigator? Not seeing any. Thanks, Angela. So commissioners, you've heard from the parties and the investigator, and at this time we'd be looking for a proposed motion. There is one, a motion. There is one proposed finding. Mr. O'Brien?
I would move that there are no grounds.
Speak up a little bit.
Trying to find the wording, but I make a motion that there are no reasonable grounds.
Is there a second?
Second.
So the motion is to find, if I might parrot the report, I think Commissioner confirmed that you are making a motion to find there are no reasonable grounds to believe that Woodland Health discriminated against Jason Dubé based on perceived disability or retaliated against him for engaging in MHRA or WPA protected activity, and the case should be dismissed.
Thank you. Yes.
So it's been moved and seconded to find no reasonable grounds on all claims raised. Is there any discussion among commissioners? I do not see any. In which case, so I will poll commissioners. The motion is no reasonable grounds on all claims. If you agree, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the finding is no reasonable grounds on all claims. And that is the last case on the commission morning agenda. I appreciate council and the parties being here. We will send a letter confirming the finding. And I know we're running a bit late in starting the afternoon session. I would, Commissioner, let me know how you feel about taking a break for a few minutes. I have the lunch for folks who are here. I'm happy to keep pushing through if you want to, or you can take a break, up to you. We do have counsel here waiting for the next case.
I think we ought to go ahead if council's here. Keep going.
Okay, so, thank you. So Commissioner, let me give you your lunch, and I will go get another contribution actually. Okay, yes. How do you feel about going to get David Weber? But will you think you'll get here for Ryan? Are we? Oh, team here. Hold on. They've got two. They have two. They have two. Okay. Here for. Yeah, he's here for Hobbs, which is the next one. All right, Commissioner, this one has mayo and mustard.
Yeah.
Pass that down.
Else said.
Everyone else, these are the same. There are napkins in here. And pass those down, please. Thank you. Thanks.
Thank you.
Next.
All right. Which one's that?
The next one is the first case on the afternoon agenda, which is Hobbs versus Lee Auto.
We're ready?
David Weber is just on his way in.
All right. Yeah, thank you.
I think it is.
It is. Just pull it open.
There you go.
What a break state property.
There should be a green light on the door.
There's a special prison for people who break states.
Okay, now we are ready.
Mr. Weber, we're gonna eat our lunch while we present these cases. Is that okay with you?
I'd rather you be well nourished.
Good answer.
They
Very
know.
good answer.
And the other option is you wait an hour.
Next on our agenda.
I don't want to get on the wrong side of lunch.
Next on our agenda is E210021. That is Zachary Hobbs versus Lee Auto Malls. This is a reasonable grounds case. At least that's one of the complaints, and as a result, we'll hear from the respondent first.
Correct.
Or
That's correct.
its representative.
Yes. I believe that Attorney Weisberg, I hope I've got that right, is here on behalf of the respondent.
Yes.
And you will also hear from investigator Colin Hurd in his first appearance. We'll get to that. Okay, Ms. Weisberg, you have 10 minutes.
Sure, thank you. Good afternoon, commissioners and members of the commission staff. On behalf of Lee Auto Malls, we thank you for the opportunity to make this presentation today. Before I begin, I want to introduce Kelly Nelson, who is also present for today's hearing via Zoom. She is Lee's Human Resources Manager. Ms. Nelson is with us today because Lee takes this matter very seriously and is committed to its effective resolution. This was a very aggressively disputed matter over the past 2 years, and we recognize the complexity of Investigator Hurd's task, establishing the truth between two very different versions of events. We commend Investigator Hurd and support all his findings except for one. We maintain our position that there are no sufficient grounds in the record to find Lee Auto Malls retaliated against Mr. Hobbs for engaging in MHRA protected activity. I would now like to summarize the points we made in our objection filing. Simply put, Lee's decision not to recall Mr. Hobbs following his permanent layoff on May 22nd, 2020 was not retaliatory. First, Mr. Hobbs remained eligible for rehire at all relevant times. Lee has produced Mr. Hobbs' separation notice demonstrating that Lee considered Mr. Hobbs eligible for rehire, and nothing in the evidentiary record shows that Lee made any subsequent efforts to change that classification or modify its separation notice for any reason after communications sent by Hobbs' legal counsel in June and December of 2020. Second, even if Lee's sales department managers had reached out to Mr. Hobbs about rehire opportunities in the summer of 2020, that outreach would have violated Mr. Hobbs' express wishes. In a letter from Hobbs' legal counsel dated June 30th, 2020, and which is included in the record, Lee is instructed not to attempt to communicate with Mr. Hobbs about his former employment and to instead direct any communications through his legal counsel. In light of those instructions, Lee's sales department managers could not have then reached out to Mr. Hobbs to gauge his interest in returning to work. Accordingly, it was reasonable for Lee to conclude, based on this correspondence from Hobbs' counsel, that they should not reach out to Mr. Hobbs about reemployment and that Mr. Hobbs had no interest in returning to work for Lee. Which brings me to my third point. After his permanent layoff in May of 2020, Mr. Hobbs never conveyed any interest in returning to work at Lee, either through legal counsel or by any other means. Mr. Hobbs never reapplied online for any positions advertised online by Lee Auto Malls after May 22nd, 2020, despite there being positions available online for which he could have applied for. Indeed, he never took any steps to return to work at Lee or signal his interest in doing so. This is in stark contrast to another Lee salesperson who was permanently laid off the same day as Mr. Hobbs, but rehired for a non-sales position on July 1st, 2020, after he submitted an application for the position on June 25th, 2020. Again, the other salesperson who was rehired applied for a position, and there were no communications or any signaling of intent or interest from Mr. Hobbs at all relevant times. And fourth, even if there were, Lee was under zero obligation to consider rehiring Mr. Hobbs. Lee never promised recall rights of any kind to any of the employees permanently laid off in May 2020, nor did Lee make any such assurances in its termination notice to Mr. Hobbs or through any other communication to him. As a matter of law, Lee has no statutory obligation to consider the reemployment of a former employee who does not himself seek to return to work. For this reason, Lee's decision not to rehire Mr. Hobbs is not adverse as required to establish a prima facie case of retaliation under the Maine Human Rights Act. Adverse requires a material change in the conditions of a plaintiff's employment. And at this point, the employment relationship had been terminated, and Mr. Hobbs has put forth no evidence suggesting he is standing as a job applicant or that an employment relationship of any kind still existed. This was not a failure to renew a current employee's employment or failure to hire a job candidate. This was a decision not to rehire a former employee who was nothing more than that, a former employee with no entitlement to have his candidacy for reemployment reviewed. Fifth and finally, Mr. Hobbs was by no means singled out. He was one of several Lee employees who was not rehired following his permanent layoff in May 2020. Mr. Hobbs was one of 3 salespersons who was permanently laid off that day, but he was one of 5 total employees at the dealership permanently laid off. He has made no effort to apply for open positions, as I've stated, and that is in contrast to one of his former colleagues. Of those 5 employees, only 2 were offered the opportunity to return to employment during the summer of 2020. Although Hobbs's legal counsel has painted quite a different picture of Mr. Hobbs being singled out, this was not the case, and we have consistently argued this throughout the 2 years of litigation. Lee and for that reason, Mr. Hobbs was not the sole exception as he has been made out to be. To conclude, we urge the commission to find the investigator erred in finding that reasonable grounds existed for determination of retaliation under the Maine Human Rights Act. The record paints a clear picture to the contrary, that Mr. Hobbs remained eligible for rehire at all relevant times, that Mr. Hobbs was not singled out, but rather was one of several Lee employees not rehired following permanent layoff. Mr. Hobbs never conveyed any interest in returning to work at Lee after being permanently laid off. In fact, on June 30th, 2020, Mr. Hobbs, through his legal counsel, explicitly instructed Lee not to contact Mr. Hobbs about his former employment. And Lee complied with these instructions, and while Mr. Hobbs remained eligible for rehire, Lee was under no obligation to consider his reemployment absent some showing of interest in reemployment by Mr. Hobbs himself. Thank you.
Thank you. Any commissioner questions or respondents counsel? Don't see any at this time. You'll have 3 minutes when we come back to you. Next, I believe, would be Mr. Weber on behalf of complainant. Yes.
Good afternoon, David Weber. I represent Zach Hobbs. I've been practicing for 37 years and in civil rights from the beginning. I don't recall ever seeing a document like the one we almost submitted to the Maine Rights Commission on December 30, 2021. They didn't talk about that in their opening because should be the end and the beginning and end of your analysis here. So on page 7, and this was a voluntary filing. It was not a stray remark. It was not a careless comment. It was not a Freudian slip. It is a whole section entitled Hobbs foreclosed any recall opportunity by signaling the possibility of legal action within a month of being notified that his layoff would be permanent. Now, the Supreme Court has said you can't, in an employment discrimination case, you can't consider reasons that are great, but the employer did not rely on at the time. So the nice list of things that the brilliant lawyers came up with that you heard today, it's not in here. And this is well after all the incidents happening. They just thought of that when they realized that this statement was a confession to retaliation. So the law doesn't let you change the reasons. Employers are not allowed to do that. McKinnon versus National Publishing, it's been on the book for 20, 30 years, unanimous decision of the US Supreme Court. So none of those reasons that they're giving now are in this section, which is on this topic. And I've never seen such a declaration of war on the human rights of employees in open court, but your open Maine Rights Commission telling you, how dare an employee ask for their personnel file because they think there was race discrimination? That is such an obvious reason. Of course, we never considered him for recall. And it goes on and on and makes that point every which way. Now, the Maine Rights Commission, this is an attack on you. And this undermines all your ability to help workers if major employers can strut around and say, hey, in writing to the Maine Rights Commission, if you dare a lawyer and ask for your personnel file and mention race discrimination, you, unlike all the other salespeople, which they've admitted, every other salesperson was recalled, one of whom did not apply, but who cares? They gave you their reason, and the reason was he dared to ask for his personnel file and mention employment discrimination. And then he really put the tops on it when he sent a settlement letter through his lawyer, in their words, on December 1, 2020. That possibility of recall was confirmed, that possibility of legal action, excuse me, was confirmed when Mr. Hodges' legal counsel issued a demand letter. It was not a demand letter, it was a settlement proposal letter, which effectively eliminated any chance that her client would be offered the opportunity to return in any capacity in the future. That is retaliation, jumping off the page, slapping you in the face and crying out for corrective action. Because the Maine Rights Commission is, if employees think that if they hire a lawyer, if they ask for their personnel file, obviously if they go to the Maine Rights Commission, they've really sunk their ship if they can sink it any more than they already have. So that's overwhelming proof. A court is likely to grant summary judgment to the plaintiff, to the employee in this situation. So equal likelihood of success, your standard is this just goes so far beyond that. It's not a close call, I don't think, for the Maine Rights Commission. Other global point I would make, if an employer has the judgment or lack of judgment to put this in writing to the Maine Rights Commission, and we look at things holistically, like juries do and judges do, there's an old expression, false in one, false in all. I'm not going to do the Latin part. If they're willing to put that in writing, what do they do behind closed doors when an employee makes a discrimination complaint? And Zach Hobbs testified that he sent an email while he was still there, raising discrimination about how he's being treated, and that the general manager called him in and said, you can't use that word. That's a very strong word. Now, the investigator blames Zach because he didn't have a copy, but you don't get to keep your emails when you get fired. And if you take them, you'll get in trouble for taking company property. So for the Maine Rights Commission to take a position that because employees don't have an email, a workplace email to support a statement that they witnessed personally, is to create an impossible burden of proof, which judges and juries do not apply. And I don't think the commission wants to get into a situation where it has a much higher burden of proof than the actual legal system that follows, that has higher standards for the plaintiff. So I would say that, you look through things, one judge called it, comments like this are a window into the soul of the decision maker. You've got quite a window into the soul of Lee Automalls when it says, how dare they hire a lawyer and ask for the personnel file? How dare they make any kind of request for a settlement based on employment discrimination? So if anti-retaliation means anything, the Maine Rights Commission should issue a finding of reasonable grounds for retaliation, and also use this as a tiebreaker on the disputed facts on the substantive discrimination. In addition, there's a few basic legal errors I just want to share with the Maine Rights Commission that just are cut and dry. Causation. The investigator's report, slips into the cause. It does not have to be the cause. This is very important. I just tried a case to a jury, and the judge was very careful with the jury. It doesn't need to be the sole cause. It doesn't need to be the primary cause. We don't like discrimination. Our country does not like discrimination. We're sick of discrimination. So if it played any role in the decision, if it's one of the factors that made a difference, it's illegal. So for the Maine Rights Commission to be putting in writing, and this has happened more than once, a higher standard then the law provides, and that's going to happen in court, just undermines your role as the front line main way to stop and prevent discrimination. We don't want to have to go to court. We want you guys to stop it. Having a higher burden of proof than the law provides just undermines your mission. And also with pretext, just because the employer gives a reason, that's not binding on the decision maker. So here they had a matrix that put him in the bottom three, even though they admitted he had unusually good sales numbers and they were giving him management duties. So it really the matrix made no sense with regard to the objective evidence in the record. And courts repeatedly say when a subjective explanation of the employer doesn't match up with the objective evidence, that is when juries infer pretext. And then finally, the investigator said he couldn't look at three denials of promotions because they were outside the 300-day statute of limitations. That's just completely wrong under settled Supreme Court case law. That can be very strong evidence of discrimination. And once again, it undermines the role of the Maine Rights Commission for it to explicitly blind itself to evidence of discrimination based on a erroneous view of the law. So the reporter has fundamental legal errors, and given the overwhelming smoking gun admission of retaliation, I would say that's at least a tiebreaker on the underlying substantive complaints of discrimination that were well supported with all kinds of comments, et cetera, in the sworn charge and at the fact-finding conference. Like I said, Zach testified, he put into writing the word discrimination in an email, and because he couldn't produce it, that was held against him. But that kind of lack of fact-finding that's consistent with pretext and our standards of proof, you should reject. So I ask that you find reasonable grounds on all the claims. Thank you.
Thank you. Any questions for Attorney Weber? Seeing none, thank you. You'll have just over a minute when we come back to you. So we'll come back to Attorney Weisberg. You have about 3 minutes.
Thank you. Let me begin by revisiting the letter that Attorney Weber had just described. That letter is the only evidence in the record of whatever pretext is being alleged. More importantly is the notice of separation, which consistently from the day of Mr. Hobbs's termination reflected that he was eligible for rehire, and this document was never changed, nor is there any evidence in the record that the letter that was sent on June 30th, 2020 by Mr. Hobbs's counsel at all trickled down or otherwise informed the Lee sales department employees who are the ones making calls, reaching out, following up about inquiries about returning to work, an inquiry that Mr. Hobbs himself never made. And thus was understandable that the Lee employees, based on this lack of interest, would not prioritize reaching out to Mr. Hobbs despite him being eligible for rehire. But I'll say most importantly, given that we're dealing with a prima facie case of discrimination and opposing counsel is not focusing on one of the elements that there's no evidence to support, which is the element of having suffered an adverse employment action. This is one of the prima facie elements that is also specifically stated in the claimant's objection filing, and it's similarly stated in our objection filing. The reason that this is important, again, is because Mr. Hobbs did not have standing to argue adverse employment action. He was not a job applicant, nor was he a current employee. When pulling a case citation in support of a prima facie claim of retaliation under the Maine Human Rights Act, Mr. Hobbs cites Lima versus the City of East Providence, which is a First Circuit decision. And tellingly, in Lima, unlike the current action, the adverse employment, the plaintiff's alleged adverse employment action was as a current employee, she was being denied the opportunities to apply for promotions within the same organization. That is clearly not the case here. We've heard nothing as to why Lee may have had some sort of obligation, statutory or otherwise, to recall or consider Mr. Hobbs's employment absent some affirmative showing on his part of any interest. And with that, I'll just say, thank you for your time and consideration.
Any commissioner questions for respondents council? Mr. David?
It's not clear to me why you resist the reasonable grounds recommendation in regards to retaliation for the Maine human rights action and asking for his file and talking about hiring a lawyer. Isn't that discriminatory?
I'm sorry, can you rephrase the question?
What is your argument that there are not reasonable grounds for Maine Human Rights Act protected activity, the fourth one, which is based on his asking for his file?
Sure. Our position is and has been and continues to be that there's no support in the record that letter sent by Mr. Hobbs' counsel on June 30th of 2020 in any way informed the actions of the employees, the dealership employees, who are the ones actually on the phones reaching out in the middle of the pandemic once economic conditions started to get like a little bit better to see who could come back. It wasn't anything decisive. It was just that we respected Mr. Hobbs's counsel's wishes as described in that letter.
Any additional commissioner questions or responding? Being none, thank you. Attorney Weber, you have about a minute and a quarter.
It's an insult to your intelligence that they're still arguing that final letter is a formal filing with the Maine Human Rights Commission should be ignored by you when they said they gave you their reason for why he was not recalled. So a court and a jury are going to get angry about that. And I wouldn't be surprised if you're not getting angry about that. The idea that you can do anything you want to a person who's not a current employee would wipe out all the laws prohibiting discrimination in hiring, for example. So it is an absurd argument. I don't
know where that's coming from. Sorry.
I'll take that as an amen. I'm an optimist.
Stop, so keep going.
Oh, and this thing about eligible for rehire, that was written when they terminated him. The request for the personnel file came in a month or two later. So they didn't make that argument when they said the reason is we sent the letter. So you can't send that to the Maine Human Rights Commission and then say, oh, wait a second, we didn't mean that now that we realize what it says. I mean, that makes a mockery of your system, and that makes a mockery of the Maine Human Rights Commission. I also can't believe we're doubling down on that today. I've never seen such a open declaration of war on the right of an employee, the basic rights of an employee. I've never seen it. Hope I never see it again. Thank you.
Okay, hold on. Let me see if there's any questions. Any commissioner questions for Attorney Weber? Seeing nothing.
Thank you.
So Commissioner, you've heard from council, and now we have Colin Hurd in his first presentation.
Good afternoon, commissioners. I'm Colin Hurd. I was the investigator on this case. I think the report pretty much speaks for itself, but there's a couple of things I'd like to highlight really quickly. So first of all, this was a very difficult case to investigate, mostly because most of the discriminatory behavior involved verbal statements made by a certain individual referred to in the report as GSM several years ago. Each party had witnesses, and each of those parties' witnesses confirmed their own side and denied the other side's statements. So really the only avenue open to me was determining credibility, and to do it from the perspective of whether or not, as the reasonable ground standard requires, whether there's at least an even chance of the complainant prevailing in a civil action in court. So it's worth saying that at the fact-finding conference and during the interviews that I did, everybody interviewed was credible on their face. I'm sure that there's some of that had to do with the natural charisma that's inherent in any salesperson job. So really, I was what I had to do was compare statements within the parties to each other and compare them to the things that I was able to verify on the record. And that led me to find more inconsistencies on the complainant's side than I found on the respondent's side. Some of these are laid out in the report, but again, just to highlight them, they involved the complainant's witness. So one of the things that complainant asserted was that he did not disclose his Iranian heritage at first because of the comments that GSM had allegedly made, and that it was.
So sorry, we don't know where that's coming from just yet. Chelsea's working.
The name John Davis popped up when
okay.
it came up.
John Davis keeps unmuting, and then we get all this noise. That's what's happening.
Okay.
It's happened twice now.
Thank you. Mr. Davis, keep your stuff on mute or we will do it for you. Thank you. Sorry, Colin, go ahead.
No problem. So the complainant said that he kept his heritage to himself because of some of the comments that GSM, I don't know if I said this already, but GSM is the individual in the report, the pseudonym for that individual, because of the remarks that person had allegedly made, and that his heritage was accidentally revealed in 2015. But during the interview that I had with complainant's own witness, that witness stated that he was very open about his heritage and that everybody in the office knew about it. So those statements didn't completely line up. There was also some indications from respondent's employment records that witness had transferred to a different dealership, and it was either mid-2014 or early 2015, and wasn't present for the events that he described. It's worth noting that the complainant in their final submission said that he came to visit the complainant, and that during those visits at work is when he witnessed some of those things. But the issues that I kind of discerned from that was the witness's statements kind of lacked specificity. It didn't seem like he actually witnessed them, that he was sort of repeating what he had heard already. Again, this was 8 years ago, 7 to 8 years ago. Some of that just might be memory issues, but the fact that he wasn't able to place himself there in a convincing way, especially involving some language that was quite profound, had an effect on my discernment of his credibility. Also, there was no indications that he did anything to help his friend. He was in the vicinity when somebody said some of these comments about his friend to him, and neither the complainant nor the witness ever said that they said anything to him or complained about him or anything like that. So those were just some inconsistencies to me that reduced the credibility on the complainant's side of things. And then last but not least, with the exception of that single witnesses, there was another witness that complainant identified as having knowledge of some of GSM's racist behavior. That witness was also present at the fact-finding conference, but he was a witness for respondent, and he had testified that he had never witnessed such behavior, that complainant had never informed him that he felt he was being mistreated, and then him and all the witnesses adamantly believed that, GSM would not have engaged in the behavior that was being alleged. Contrary to complainant's witness, respondent's witness, witnesses were consistent with respondent submissions and with their own testimony. I didn't find any inconsistencies there. And then the last thing I want to highlight is this one incident or incident is probably the wrong word, but one issue that really stuck out to me was in complainant's second and third amended complaints, he asserts this issue of the orphan customers. And I'm assuming that you've read the reports. So the orphan customer is like a customer that hasn't had a salesperson assigned to them in a long time. They haven't been contacted. In the complainant's complaints, he said that these customers were given to him in 2019. It came out later that it was actually 2017. The year difference didn't necessarily make a difference, but it was also connected with an event that was not brought forward by the complainant, which was that he had in 2017 given notice to respondent that he was going to a competing dealership, and in the process of that, they took away the customers from him in this software, this system that they use. And then they would have had to reassign all those to him when he decided to come back. And I guess that was a very difficult process. This whole thing is a sort of standard practice in the industry. So the fact that the years were wrong, that he wasn't forthcoming about the fact that he had actually tried to leave, again, just kind of were hits on the credibility for me. So that's why I reached the no reasonable grounds conclusion when it came to the racial discrimination in this case. And with all that, I'm ready to take questions.
Okay, Commissioner questions for Colin? Commissioner David?
Colin, do I understand you to say that you, as a matter of credibility, you don't believe that the language was used with the N-word and, reference to the desert?
I think that the best way to answer that question is I can't say for certain whether it occurred or not, but if you really what it came down to is the fact that there seemed to be more inconsistencies on complainant's side than on respondent's side of the coin.
And what are those inconsistencies?
Well, the orphan customers thing that I just mentioned, and the complainant's witness whose own testimony didn't really coincide with complainant's own testimony.
Okay.
Any other commissioner questions for the investigator? Seeing none. Thank you, Colin.
Thank you.
So commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion or motions. There are 3 proposed findings. Commissioner David?
Well, I'm going to take the third. I'm going to take the low-hanging fruit. I move that we find that there are reasonable grounds to believe that a respondent retaliated on the basis of MHRA protected activity, and conciliation should be attempted.
Is there a second?
I'll second.
Commissioner O'Brien? So it's been moved and seconded to find reasonable grounds to believe that Lee Automobiles retaliated against Zachary Hobbs for MHRA protected activity. Is there any discussion among commissioners?
That's the one that's based on the asking for his file, and I think that's pretty clearly retaliation. That's clearly protected activity, and so the adverse employment action is retaliation.
Any additional discussion among commissioners? Seeing none. So the motion is to find reasonable grounds on MHRA retaliation. If you say yes, you're in agreement. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So that finding is reasonable grounds. Commissioner O'Brien? I would.
Another motion?
Yes.
Okay, I would move that there are no reasonable grounds to believe that Lee Automobiles discriminated against Zachary Hobbs on the basis of race, color, ancestry, or disability, hostile work environment, discharge, and should be discussed.
Is there a second to that motion?
Awesome.
So it's been moved and seconded on the first proposed findings regarding no reasonable grounds regarding race, color, ancestry, or disability discrimination. Is there any discussion among commissioners? Seeing none. If you're in agreement with the no reasonable grounds finding, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
No.
So that's a 3-2 vote, and the motion is upheld for no reasonable grounds finding. Let me just write it down so I know who's who. Okay, and we need one more motion.
I'll move. There are no reasonable grounds to believe the respondent retaliated against complainant for engaging WPA protected activity, and that claim should be dismissed in accordance with the act.
Is there a second?
Second.
So it's been moved and seconded to find no reasonable grounds to believe that respondent retaliated against complainant for WPA protected activity. Is there any discussion among commissioners? Seeing none. So the motion is for no reasonable grounds. If you vote yes, you're in agreement. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So that finding is no reasonable grounds, and we have 1 reasonable grounds and 2 no reasonable grounds findings. The commission will send parties and council a letter confirming that, and we thank you very much for being here today. We're getting closer, only 2 cases left.
Next on the agenda is 822-0317 A and B.
Oh, I'm sorry. I apologize, Commissioner. Thank you for reminding me. And I'm very sorry for interrupting what you're saying. I was supposed to ask you a case that you decided you voted on late in the morning, which was Davis versus Penobscot County Commissioners. Complainant did not appear. Complainant has now logged into the meeting and explained to me in the chat that, let me tell you exactly what he says. He says, "I'm so sorry, I've been trying to get back on as I was on when you spoke my name for the meeting. My computer needs replacement for sure." So it is up to you to decide whether to vote to reconsider your finding from this morning.
I move that we reconsider our finding of this morning. That's reasonable, especially if he was on, as we were calling his case. I'll leave it at that.
Okay, hold on 1 second. Right down. I lost track of my stuff. Lost it all together. So the motion was Commissioner Ashby and seconded by Commissioner Davis. And the motion is to reconsider the finding your vote in Davis. So it can be reheard. So it has been moved and seconded that the commission reconsider its vote this morning to find no reasonable grounds in case E210404 Davis versus Penobscot County Commissioners. Is there any discussion among commissioners? Commissioner O'Brien?
Yes, I personally am very sympathetic about computer issues. I get it.
We've all been there.
We've all been there.
So the motion is to reconsider the vote this morning and to hear the case. It would have to be heard in March because Respondents Council is not on the call anymore.
Oh, okay.
So if you are in agreement with hearing the case, but doing so in March, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay, so the commission has voted to reconsider its finding this morning of no reasonable grounds in the case of Davis versus Penobscot County Commissioners. I will reflect that in our minutes and let counsel for respondent know and complainant. We will send you a letter confirming that the case will be on our March hearing agenda. And with that, we can get back to the statement that you were in the middle of.
Fair enough. Next was H220317 A and B. That's C. Clifford Roy and Jessica LaGrange versus Albert Bazinet and New Realty. That's a no reasonable grounds case. Suggest we would hear from one or both of the complainants.
Yeah, I believe that they are in the same or appearing together.
Yep.
So to Ms. LaGrange and Mr. Roy, 10 minutes, and I would ask that you just be aware, remind you not to use the names of any third parties.
Okay.
And just so you know, we can't quite see your face, so if you wanted us to see your face, thanks.
That's fine. Okay.
All right, the other way around.
Let's see.
Yep, we can see you.
Okay.
Sorry about that. Where do I, okay, where do I, no, you gotta, okay, so
I'm trying.
okay. We are here basically because we disapproved the call that you guys did. We had terms that we had disagreed. And I'm gonna come out and say me and my fiance both have disabilities. And I'm gonna start with the first date that the incident happened. It started with 9/21/2020, where we had my landlord, Albert Bazinet, came over and harassed us because of a complaint, interaction with one of our neighbors, which I had to put a PFA on, which I felt, you know, him coming over and harassing us because of it. And I tried to show him the papers, which I even did the video recording of the evidence. And I felt like that raised a point of, you know, hostile environment complications. So I felt this is where I start. And from there, it continued to May 9th, 2021, when my fiance was discriminated because of his disability. Explain from that.
Yeah, I was sitting outside and he came by with his truck and he came outside and I was sitting by myself and he had asked me, you know, personal questions like, how come I don't work? How come I don't have a job and stuff like that. And I had told him that I was on disability. And then he wanted, further details as to what my disability consists of, which I didn't tell him because it was personal and stuff. And he's even had his workers come over here. One of the guys that works for him, Sam, and stuff like that. And he saw me outside one day and he says to me, he says, hey, he says, I hear you're a homosexual. And I says, the hell are you talking about? I said, I ain't no homosexual, you idiot. So then he stated the last meeting that we had too, that he would come over here and pick up the rent, which he's not the one that comes over here and picks up the rent. It's usually his son, Jim, that comes and gets the rent. And I get along with his son, but as far as Bill goes, the father, he's a hard guy to get along with. And so anyways, I'm just gonna try to think, yeah, he came over here another time too. And he a lot of times when he would come by, sometimes he just sits in his truck and then he'll just sit there and he'll just wait for me to get up and go up to him and see what the heck he wants. And I've been living here for like 5 years now. And since I moved here, I had my flags outside because I like to collect flags. And some of them have to do with my ethnic background. I get French and Scotch and German and stuff. And he was complaining about the flags and saying, that, oh, it's an eyesore and stuff like that. When I told him, I says, look, I says, there's been no complaints from anybody. I says, has there? Anybody complained? He says, well, no one complained. So then he would say stuff like, "Oh, it's gonna damage the trailer in the wintertime and stuff like that," which it didn't damage the trailer. And besides, usually in October, at the end of it, October, I always take my flags down, so that way it doesn't, do anything wrong. But it never damaged anything. So I asked him, I says, well, if you're not asking me to take the flags down, I says, then why are you here? And he says, well, because he says, I'm just here to harass you. I says, oh, so you're here to harass me, And I told him, I says, there's nothing wrong with, my signs that's outside, which is no trespassing, or the flags. I says, it's my First Amendment, it's my freedom of speech right there, But he just kept on harassing, and my fiance called the cops, and the cops told me.
Oh, we can't hear you right now? We can't hear you right now? I'm not sure why, but we can't hear you. I can see that you're speaking, but we can't hear you.
You mean I've been talking all this time?
There you go. There you go. You came back.
Okay.
Oh, which part didn't you not hear?
Well, I couldn't tell you. I couldn't tell you which part I didn't hear because I didn't hear it.
Oh, you didn't hear nothing that I've said so far?
No, we heard about 6 minutes worth. We just didn't hear maybe the last 10 seconds.
Okay, you heard about when I told you about him coming over here and harassing me because of my flag, stuff like that?
Yep.
Oh,
So
okay.
last 10 seconds of what you said.
The last part of it.
Okay, so we called the cops, and the cops came over here, and there was 3 officers, and they told him that he has to leave and stop, harassing us and
And it's
stuff.
on the, it was on the also police report that we submitted, showing that, he was at our place sitting there. And he refused to leave, basically.
Yeah.
And I want to bring up also on 5/9, when the submission I sent on the recording of the call that what the situation happened that day with my fiance being discriminated. I had also been discriminated, and I didn't feel like, if I would say I have a disability, he's gonna make, he would laugh at it. And it really made me upset, really inside deep. And I'm like, he's like, well, you need help. You need you're sick. You need mental help. And I'm like, I felt very angry inside at that point. And it was all on video when I did it, because I was disappointed that he came over and harassed us. It's like hostile. It's like very hostile. It's like continuing. Then on 8/12, when he came over with about the flags, there was no reason. He had on our list, it does mention that he has to have 24 hours to with a notice, with a to even come over and look at our place. And we didn't even get the 24 hours. It's like privacy, what's considered privacy, coming over and interfering our enjoyment of everything.
Right.
And when he also mentioned in the video on the 20th, on the August 12th, he said he was going to harass us every day.
it's like, it didn't make me feel any good. Both of us didn't feel good about it. It's just like,
Yeah, and then the week after,
then on August 20th with
the week after,
August 20th, where
you relax.
yeah, because of when I went to I came back from the store, I had I saw Mr. Basnett, you know, pass me and parked at a trailer, the first trailer to the entrance. And when I walked past him, he kept on looking, you know, staring at me. It made me feel uncomfortable. Then by 5-10, you know, seconds like later, he started, you know, moving, you know, inching up. That whole day, you know, I felt, you know, uncomfortable, you know, very uncomfortable.
And then what?
And with I disagree with the retaliation, where to do with the rent part, increase. I had to submit, you know, to a letter to Mr. Basnett stating that, you know, he couldn't raise up the rent because of the.
Ms. LaGrange, Ms. LaGrange, I'm sorry to interrupt you, but you have used up your 10 minutes.
Okay.
So I'm gonna have to ask you to stop. So at this time, I will turn to commissioners and see if they have any questions for either of you two. Commissioners, any questions for complainants? I do not see any questions. So thank you for presenting. I'm going to mute you at this time because that's the end of your time. And we're going to turn now to respondent's attorney. And that, I believe Mr. Dion, I'm sure I pronounced that wrong, is here.
Yeah, that's all right. I do go by Dion, but I get
Dion,
Dion.
sorry.
No worries. In this case, I believe the investigator's report is fairly thorough, goes through each of the particular allegations that were made, takes the evidence that was considers, and I think results in the proper analysis. This particular instance, Mr. Bazinet's conduct and the conduct of New Realty have really nothing to do with the national origin. Disability and the rent raise had nothing to do with retaliation. Essentially stand by the investigator's report, and I'll be happy to answer any particular questions that the commission may have.
Questions? Sorry, I forgot that he's gone.
She was quiet.
You will have just over 9 minutes left. When we come back to you.
We had a very thorough report, so I'm not going to put the commission any further behind in schedule.
Thank you. Commissioners, any questions for Mr. Dia? Seeing none, we will turn to Angela.
Hi there, Angela Morse again. I was the investigator assigned to this case. So this was a fairly fact-heavy case. There was a lot of dispute over what actually occurred, but after, through my investigation, I simply could not conclude that discrimination occurred based on sex, disability, or national origin, or that there was any retaliation for engaging in MHRA conduct. There simply was not enough credible, objective evidence to make that conclusion.
Questions for Angela, commissioners? Amy to be shocked when we're done with this case. Seeing none, we would be looking for a motions. I'm not at the end of the report yet. Looks like there are 2 recommendations. You can take them together or one at a time, as you please.
No, there's only one.
No, there's one. What am
Well,
I
there's one
looking
that
at?
is
I'm looking at the next case.
Well, there really is, there's one proposed finding,
Yeah,
but it has the 2 respondents. It could be, we could break that up, but I'm not encouraging anyone.
All right.
Make a motion.
I will. I move that there are no reasonable grounds to believe that that either respondent, Albert Bazinet, and for New Realty discriminated against complainants, either complainant, on the basis of sex, disability, and or national origin, or retaliated against them for engaging in act protected conduct, and the complaint should be dismissed in accordance with the act.
There's a second.
Second.
So it's been moved and seconded to find no reasonable grounds on all claims. Is there any discussion among commissioners? Seeing none. So commissioners, if you are in agreement with the no reasonable grounds motion on all claims, we'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds on all claims. We thank all the parties and council for participating today. The commission will send you a letter confirming this. And we have one more case.
The last case is E20-0544. That's Edgar Randolph versus Rockland Marine Corp. That is a reasonable grounds case. You should hear from the respondent.
Now, I just want to make sure that we have complainants counsel on here because I don't see that.
Morning, Ryan Schmitz for the complainant. I'm here. Thank you for checking.
Okay, I just didn't recognize your, I see now, Johnson Letter. Okay. Okay, so Attorney Langsdorff, you have 10 minutes.
Thank you very much, commissioners. I am here this afternoon to argue a case against, in part, investigators' finding on behalf of my client, Rockland Marine. So what this case was about, Edgar Randolph had been an employee of Rockland Marine for 15 years. During that time, he was a very good employee. He was well respected at the employer. And during that 15 years,
all right, B.
I'm sorry, where's that coming from?
Well, it wasn't me.
I'm going to mute, and I believe this is where it came from. It's still Pippin Hill. I don't know who you are, but you're not allowed to speak at this juncture, so I'm going to keep you on mute.
Okay, so during the 15 years that he worked for the company, at no time did he ever complain to the company that he had in any way been treated unfairly because of his race or because of his age or for any reason. The company has a very strong policy against all forms of harassment and has a very clear policy with respect to who claims or any problems of that nature should be reported to. Not only did he not make any reports during this time, there were numerous opportunities where there were other situations that had been investigated, including a very specific case in 2017, where another Black employee had made some claims against the company, and the complainant here was interviewed very specifically, and it was recorded. And he made it known that absolutely none of that kind of thing had happened to him, that he was not shy about it. And if there was a problem, he would bring it up. So what the case was actually about was that Mr. Randolph made a mistake, and he unfortunately cut corners in his job, and they work on ships, retrofitting ships. And he took a very long, heavy metal object, and rather than carrying that object down through the ship, he threw it over the side of the ship, and it landed on a dock area. It was witnessed by the vice president of the company, who was extremely upset about what had happened, and consulted with the company president and terminated Mr. Randolph for that the next day. And the investigator did support that Mr. Randolph's race had nothing whatsoever to do with his termination, which was the primary allegation. There were a number of other allegations that were raised of things that happened many years ago, but in particular, the investigator found that the 2017 denial of all those things really put that to rest, as well as the fact that they were time barred. So what actually, and the only evidence that the investigator in this case ended up finding that there was some hostile environment liability were some allegations that were not brought up at all in the complaint. And the first time that they were raised was in the fact-finding hearing without any names being raised. At the very close of the evidence, the investigator asked that alleged supervisors who were not supervisors in the sense of management of the company or owners of the company in that respect, but basically a foreman and a dock sort of crew leader had so supposedly been waving around a black foam pipe and making some comments towards Mr. Randolph. He wrote in his closing letter that he intentionally did not report this to the company because he just felt that nothing would be done about that, even though in this meeting in 2017, he'd been closely talked to and he had said that there weren't any problems. Not only did he not report this to the company, but in 2020, this was in the record, there was a very specific meeting where Mr. Randolph, he had not been acting like himself and seemed like he was upset about something. He was asked specifically, is there something going on in the workplace that is bothering you? And he denied that and said, no, that's just a personal problem that I'm having here. So there are several reasons why this is not a legitimate basis for liability against Rockland Marine. And as the investigator did understand that the legal standard correctly here, where it was indicated that here where this was not, in particular, the issue of the harassment, alleged harassment, is not a tangible employment action, that the company has an affirmative defense of showing that it took reasonable care to prevent any harassing behavior, and that Mr. Randolph unreasonably failed to take advantage of those corrective opportunities. Well, it was abundantly clear in the record and wasn't denied that there were a number of meetings that occurred where harassment and issues in the workplace were discussed and how to make things work better in the workplace. There were personal meetings with Mr. Randolph. There was a strong policy and so forth. And so the company did all the things that it could have done to prevent this type of behavior. But it was very clear that Mr. Randolph simply did unreasonably fail to take advantage of corrective opportunities. The company was not on notice at any time these events had occurred. The employees that were involved in this, if it happened at all, were not the employees who were supervisors as defined by law. They weren't responsible for hiring, firing, salaries, or any of that nature. That was testified to specifically by Reagan Perini, the now president of the company. There was only he and Jim Corcoran, the president at the time, who had the authority.
Mr. Langsdorff, can you please not use the names of third parties?
Excuse me, other employees, the former president of the company, they were the only ones who were in the position to make those types of decisions, and testified absolutely nothing came to their attention. It's undisputed that this was not reported to the company. So for all of these reasons, is our position that in this particular context, it would be absolutely unfair to hold the company responsible for alleged actions of low-level types of employees overseeing other employees, where simply no conduct was reported, even though it was available and made clear by the company that they cared very much about having a good and strong work environment, preventing these types of discrimination and so forth from going on. And therefore, there was no basis here at all for any type of finding of discrimination against Rockland Marine. Thank you. I'll be happy to answer any questions.
Thank you. Commissioner questions for respondent counsel. Commissioner David?
Attorney Langsdorff, the report indicates at the top of page 2, respondents' employees in the plural and supervisors in the plural, including owner, frequently use racial slurs to refer to subcontractors from Central America and Puerto Rico, told them to go back to Mexico. That's after a recitation of the other conduct using the N-word. And you're saying that all of this never happened, or they didn't know it was happening?
Well, first of all, that's not, those are not the findings of the investigator. In my belief, those are the allegations, right, that were made, and they were absolutely denied by the respondent that they used that type of terminology. And so that occurred, but that was very much denied. And that there was no finding that I saw from the investigator of any of that. The only thing that the investigator found was this issue over the waving the pipes around. That was the only finding that related in any timely manner or at all that I found in that report relating to conduct of the respondent.
And in response, in regards to that, that conduct, which you describe as waving the pipe around, the allegation is that it's two supervisors, the dock master and the foreman.
Yep.
And you say that never happened, or it's misinterpreted as to what the behavior was about?
Well, what was in the record, well, the allegation and the salient point here is that conduct was not reported to the company. These are not the type of supervisory employees that are automatically the company itself, which are the law shows that the supervisors are defined as decision makers, people who hire, fire, responsible for salaries. These are the people on the dock who said, go pick up that pipe, go over here. These are not management employees on that level. And the law does not find that you're automatically responsible under that affirmative defense that I was identifying, as long as the company is taking a reasonable care to prevent, and he unreasonably failed to report, we're not responsible. It says in his letter very specifically that Randolph chose not to report that activity to company management because he thought it would be futile for whatever reason. He made a conscious decision not to report it.
Okay.
Any additional commissioner questions for respondent?
I do have one. When was the incident about the ice scraper being thrown over the side of the ship?
That was in June 2020. That was the day before he was terminated.
And was there a employee discipline procedure in the company?
Absolutely. They have progressive discipline policy, but obviously certain acts under any progressive discipline policy are considered to be so severe that they warrant termination. In this case, that was this type of extremely unsafe act, and the investigator found that the termination was directly related to that and nothing to do with his race.
Okay.
Mr. Ashby?
Attorney Lankdorf, you referenced, I'm going to paraphrase, but in your presentation, you referenced the sort of check-in on the part of the respondent to inquire of the complainant whether or not things in the workplace were okay or whether he was feeling having been harassed. Are you referring to the response back in 2017 to his complaints about allegations of race-based discrimination, or was there a meeting closer in time to these 2019, 2020 allegations of these supervisors waving the pipes around?
It's a 2020 meeting. There was testimony in the record that occurred, and Edgar said he recalled that happening, didn't remember all the details of what happened at that meeting, but he did remember that happened in 2020, where company management specifically went to him to ask him why he seemed to not be himself. So that was after these allegations that he's making in 2019 and 2020, and not long before he ended up being terminated.
Thank you.
Any additional commissioner questions for respondent? Seeing none at this time, you'll have about 3 minutes when we come back to you. And we'll turn to Attorney Fitz.
Good afternoon, everyone. Thank you very much. My name is Ryan Schmitz. I'm here representing the complainant, Edgar Randolph, who's sitting to my left. So we don't have too much to quibble with the investigator's report. I think the factual findings pretty much speak for themselves in terms of the disgusting conduct of members of both like the management class of Rockland Marine and the workers, and the sort of severe and pervasive environment of racial and age-based hostility that Mr. Randolph had to deal with for his 15-year career at Rockland Marine. So you've seen the investigator's report. It mentions a lot of things. I do want to make one point, which is that I don't read anything in the investigator's report to suggest that anything that happened before this 2017 meeting was time barred. Certainly the 2017 meeting is a sort of a point of focus on in the investigator's report, but it absolutely doesn't say that any of the conduct before the 2017 meeting is somehow time barred from this claim. I'd also like to point out to the commission that there's a theory of liability that involves sort of continuing violation. I know you're aware of, but I mean, this is the investigator's report certainly takes into account that this was a consistent environment that lasted the entirety of his time there. I mean, there's plenty of case law to suggest that any one of these sort of discrete examples of racism, including use of the N-word and use of the phrase colored people to refer to Black people, that phrase was being issued as the investigator, or used as the investigator points out, right up until Mr. Randolph's termination, despite his consistent attempts to get them to stop. You know, there's a lot of hay being made over the fact that Mr. Randolph chose not to report these issues to that his two supervisors, a dock master and a shop foreman, were waving black pipes and asking Mr. Randolph if it looked familiar to him. And this was, again, a consistent practice, not an individual momentary thing. That he didn't report that to you know, the people above those people. I think that the evidence shows, and it's well within the record, that the issues with racism and age discrimination are riddling the management class of this company. I mean, we even have the president of Rockland Marine himself addressing some of the more gross, you know, discriminatory harassment from some of the workers, saying, look, guys, we've all made jokes before, but we're going to have to kind of pull back on that. And you know, he's the one who is, Commissioner David, as you pointed out, he was the one who talked about, you know, when they needed some temporary workers, talking about how they need to bring in a bunch of Mexicans. This is not an environment where a worker who is, you know, just trying to keep his head down and do his job can go to management and you know, expect any sort of sympathetic ear, which is a big part of what informed his decision to, you know, again, put his head down and you know, say that he wasn't experiencing discrimination during that 2017 investigation. I mean, the fact is that this was a scary environment to be a person of color. There are almost no people of color at this company. And so he said what he thought he needed to say to keep his job. It's important to note that he was approached by the president of the company himself to say, hey, look, this lawyer is going to come in as part of this investigation. He's going to want to talk to you about it. And I mean, I think that's a reasonable employee who fears for his job, you know, would interpret that as an, oh God, you know, I gotta, you know, keep this buttoned up. Otherwise I could be in real trouble here. It should be noted that investigation, what he said, it wasn't under oath. It wasn't under some sort of penalty of perjury. He just, again, said what he needed to say. Just to, you know, the one area that I would like to disagree with the investigator's report is as to the wrongful termination claim. There are a few things here, but I think the big kind of legal issue here is the sort of taking the employer, Rockland Marine's, reason for the termination at face value, basically saying, well, he dropped the pipe off the side of the boat, and therefore that's the only reason that they need to say that there was no termination. That's the only reason. That's the only thing. But as the Supreme Court has said in Bostock, that's just not how causation works. As long as a protected category like race or age is a reason, one of three strikes, let's say, for you know striking somebody out, then that is enough to establish causation under Title VII, and you know, accordingly the Maine Human Rights Act. And so while we don't dispute that there was a mistake made on that day, we do dispute or we do take a lot of exception to the idea that just because he made a mistake, despite having up until that point a flawless safety record, which is in, with the evidence of which is in the record, we dispute the idea that that he, they're skipping over all of these progressive discipline steps, for one of the two current Black employees in June of 2020 and fired him. The other key sort of evidence of pretext that I think is really important to highlight here that the investigator's report does not discuss in the analysis is comparator evidence. Is that, okay, we have this reason that they give for their termination. Well, how are other coworkers, particularly younger white coworkers, treated? I mean, there's evidence in the record that shows that despite, an accident leading to the long-term, perhaps permanent disability of a coworker, the individual responsible for that accident, the same individual who would wave pipes at Mr. Randolph every time he walked into the machine shop, he was not fired for that. It should also be, emphasized that no one was injured. Mr. Randolph took steps to make sure that there was no one underneath the boat when he dropped the ice scraper off. Despite that, he was immediately terminated. And so that mixed with the, sort of excellent performance record, the rapid jump in progressive discipline, and then the comparator evidence of younger white workers sort of getting away with, significantly more dangerous and harmful infractions, I think is really, it screams pretext here. And I just don't think the investigator's report really probes that in any significant way, which is why I believe the investigator erred when determining that there was no hostile work when determining that there was no wrongful termination here. So with that, I'll take any questions the commissioners might have.
Thank you. Any commissioner questions for complainants counsel? Seeing none. You'll have about 2.5 minutes when we come back to you, Attorney Schmitz. We'll come back to Attorney Langsdorff. You have about 3 minutes.
Okay, thank you. Just a couple of points. The investigator makes it very clear that the finding is based solely on the activities in 2019 and 2020. She states, they state, setting aside allegations of anything that took place before his interview in 2017. So there's no indication of a continuing violation. And I thought it was interesting. I had not heard this one before in this matter, I don't believe, but now the complainant is not only saying that he intentionally didn't report this information to the company, but when he was asked to give a statement voluntarily to a lawyer and so forth, that he just lied during that and just said what he should say instead of being honest and using that as an opportunity to report information to the company. So he's asking you now to find in his favor by not reporting something and then actually misrepresenting the situation to the company. Now, this case was extremely well investigated, very thoroughly for a period, of 2 years, and all this information about comparative evidence and so forth was brought up. There was no evidence at all that the termination was related to Mr. Randolph's race. It was a very unsafe thing. When you hear ice scraper, don't think about one of those little plastic things you scrape your windshield with. This was like an ice pick with a heavy metal end on it and 4 feet long and so forth that dented the concrete after it fell over 40 feet through the air. And there was no way to take precautions to make sure somebody wasn't walking out of the bottom of that ship. And it was the kind of thing that almost anybody, probably anybody would have been terminated for, under the circumstances, and he was. So let's be very clear about this. This case relates only to these allegations in 2019, people working on the dock with him, not reported, plus plenty of opportunities, and apparently misrepresenting, according to him, in 2017, and misrepresenting again in 2020 when the company could have taken action. This is why we have this type of affirmative defense before a company is held responsible, for something that happens in the workplace. They must have a reasonable opportunity to deal with it. Obviously, if there was this long, ongoing period of harassment, it would have been described that way in the report, and it wasn't, because of the statements that had been made many times of Mr. Randolph. There is simply no basis in this case for a finding against the employer of any nature. Thank you.
Thank you. Any questions from commissioners or respondents counsel? Seeing none. Thank you, Attorney Langsdorff. Attorney Schmitz, we're back to you. You have 2.5 minutes.
Okay, thank you very much. I'm going to read directly from the investigator's report because I think that speaks a little bit more truthfully than either complainant's counsel or I could as to this issue with setting aside. On page 3, point 3 sub C, complainant witnessed or was subject to both discrete and ongoing derogatory race-based behavior from his coworkers during this time. Prior to 2017, coworkers used the N-word in his presence, sometimes referring to him. In or around 2010, a stuffed gorilla was left in the break room with a tag labeling it, quote, this employee's brother. This employee was a black man, one of the only other black men who worked at Rockland Marine. The employee in question was the only, there you go. The employee in question was the only other black employee at the time. Employees and supervisors, including the owner, made inappropriate jokes. That's a fact that was found by the investigator. I think it's frankly ridiculous to say that, you know, that doesn't play any sort of part in the final analysis of a determination that there was a hostile work environment. And so this sort of bifurcation of, well, there was, you know, we don't even have to think about the racism that happened in 2017 or before 2017. Well, you know, it certainly doesn't vitiate the racism that happened after 2017. Nothing in the investigator's report suggests that it's not a part of this overall hostile work environment that Mr. Randolph experienced during his 15-year-long career. Thank you very much.
Thank you. Any commissioner questions for complainant's counsel? Seeing none. Thank you to both counsel, and the investigator was Kit Thompson-Crossman when they were an investigator.
Actually, wasn't the investigator on this case, but I did write the report.
Okay.
I don't have much to add except that for me, one of the most important factors in making the determination about the hostile work environment was the fact that the frankly disgusting allegations about the foam pipes being waved around was made at the Issues and Resolutions Conference, was not addressed, continued not to be addressed after the parties had an opportunity to respond, and that just seems sort of glaring to me. I'm happy to answer any questions.
What do you mean by not addressed?
I mean, so it was alleged at the conference, and then it was.
They didn't deny it?
They didn't. There was some general denials of like, no, this stuff has never happened here, but there was no specific denial about the pipes. And then the investigator gave the parties, asked for some further information. Complainant, again, with more specificity, alleged this thing about the black foam pipes being waved at him when he walked into the machine shop. And the respondent didn't deny it, didn't address it, didn't say anything about these employees and our supervisors until after the report was issued. I hope I didn't answer any questions.
Commissioner O'Brien and then Commissioner Douglas.
Thanks. Okay, so that incident is egregious. I would agree. Did I correctly hear you say that did I hear correctly that absent that incident, but for that incident, the incidents were before the 2019 or whatever it was, and that it wasn't a timely report?
So there is consistent reporting both from complainant and frankly from respondent that it's been a racially at least charged, if not hostile environment for a long time. In 2017, I'm sorry, I may be getting the time a little confused here, but in 2017 or 2019, management took some steps to address that. They held a meeting. They said, look, everybody's been making jokes, which I think we can all agree is not a great way to address a racially hostile environment, but that's what they said. And we all need to pull back. Complainant did have this interview in 2017 in relation to a different case that was going on where he seemed to indicate that he was the sort of person who would say something if he was offended. At that point, though, the black pipe thing wasn't happening. He said all of that to respondent, and then coworkers at least openly continued to refer to people of color as colored people, even though he had on some occasions tried to explain to them why that was inappropriate. So there's an ongoing pattern at this place regardless of complainant's motivation in saying he wasn't offended or he would say something about it, it was clear that after that, when the pipes started getting waved around, that he was offended, which I think is perfectly understandable.
I'll say Commissioner O'Brien. Commissioner Douglas.
Yes, good afternoon. So the complainant alleges that white employees were treated differently with respect to the termination, right? They engaged in much more dangerous activity and they weren't terminated. And I was curious the extent to which you feel that your investigation confirmed these allegations.
So there are a couple of things specifically alleged by a complainant that white employees did. One was a general allegation that employees were dropping like steel plates basically off of these I need to call them boats. They're huge ships. I don't know what the appropriate term is, but they're massive. And that was credibly refuted. Just that it's not, these steel plates are incredibly heavy. People aren't just like, well, like cutting them out of the ships and letting them fall. There's a sort of a procedure for that. And the other thing that was alleged was that, and this did happen, that a smaller boat, while they were moving it, fell and I think broke an employee's leg. And that one of the people who later was waving these black pipes around was one of the people responsible. That was pretty clearly an accident. They had tied ropes onto two eyes that were welded onto this boat that they were moving. And as they were moving it, one of the eyes came off. It just like popped off the boat. The welding, I guess, wasn't strong enough to hold it. The wind caught the boat and the boat fell on this employee's leg. It was an accident. It was not great, obviously, but that was accidental, where complainant intentionally dropped this ice scraper off the side of a 20 or 30 foot boat ship. So that was, I did look at the comparator evidence that was offered, and that just didn't seem to be quite on the same level as dropping this thing off the side. That plus the contemporaneous evidence is like, Vice President was clearly shocked that had happened. Like there's evidence in the record that he like ran out of the office when he saw this happening. He was like, what did you just do? Why did you do that? That was evidence to me that the discharge was not discriminatory, was based on something like he, regardless of how severe it might actually have been, clearly felt that it was severe enough to warrant that sort of discipline.
Okay, thank you.
Commissioner Greenberg?
Do you know if those the incident about the boat being blown off subjected the employee to the progressive discipline? There was an investigation about that?
I don't. That happened in 2016. I'm sorry, I don't believe that's in the record.
And what did the complainant say about the ice scraper?
So the complainant said that he was on sort of the top deck. It's a ferry boat that he was working on. He was on the top deck. He had the ice scraper. He says that he shouted sort of a warning. I think he shouted fire in the hole or asked if anybody was down there before he dropped the ice scraper off the side, but then he dropped it off the side.
Thank you.
Any additional commissioner questions for the investigator? Seeing none, thanks, Ken. So commissioners, you've heard from the parties and the investigator, and at this time we'd be looking for a motion which Commissioner David appears to have at the ready.
Yes, I'd like to make a motion on both of them and take them separately. I move that we find that there are reasonable grounds that respondent discriminated by creating a hostile work environment. Conciliation should be attempted.
And you are referring
Second.
Hostile environment based on race, national origin,
Yes.
ancestry, and/or color.
Right.
And Commissioner Douglas second. So it's been moved to find reasonable grounds on proposed finding number 1 regarding hostile work environment. Is there any discussion among commissioners?
I don't want to take a lot of time in discussion, but it seems open and shut to me. This is over years of time. It's multiple employees. it's throughout the respondents' operation, and they knew about it. And this argument that the complainant could have complained more rather than being sort of beaten down and deciding to put up with it is not persuasive to me at all. So I think it's clear that it's a hostile environment.
Any additional discussion among commissioners? Seeing none. So the motion is to find reasonable grounds based on hostile work environment from race, national origin, ancestry, and or color. If you vote yes, you are in agreement with the reasonable grounds finding. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the first finding is reasonable grounds. Commissioner David.
I'd like to make a motion that we find that there are reasonable grounds to believe that there was discrimination by discharging it on the basis of race, national origin, et cetera, and that conciliation should be dismissed. So I'm making a motion contrary to the investigator's report, and I'll speak to that if it's seconded.
Sure. Is there a second?
Second.
So it's been moved and seconded. Is there discussion among commissioners? Mr. David.
You know, the point is that it's a hostile work environment and that it's pervasive, and that colors the way that he's treated over this incident, about which there is dispute. Is it 40 feet? Is it 20 feet? Did he look over the side? Stupid thing to do, but I worked in shipyards and I worked around ships. He threw the ice scraper, anybody there, and he threw it off. I think that the environment cannot but color the quick execution of, oh, you're fired, without following their own policy to investigate that and give him a chance based on his record to explain that or to be really clear about what the circumstances are. The investigator found the vice president credible in his immediate upset, but it still doesn't obviate the need to have an investigation as to exactly what he did see and when he saw it. Did he hear what the employee says he said or didn't say? It's the violation of a policy of discipline that leads me to make that conclusion in the context of a hostile work environment, which we've already found.
Any additional discussion from commissioners? Seeing none. So the motion is to find reasonable grounds regarding discharge on the basis of race, national origin, ancestry, color, and or age. If you're in agreement with the reasonable grounds finding, you vote yes. Commissioner Ashby.
No.
Commissioner David.
Yes.
Commissioner O'Brien.
No.
Commissioner Walker.
No.
Commissioner Douglas.
Yes.
So the motion fails with 2 in favor and 3 opposed.
I'll move that there are no reasonable grounds to find that respondent discriminated against complainant by discharging him on the basis of race, national origin, ancestry, color, and age, and this claim should be dismissed in accordance with the act.
Is there a second?
Second.
So the motion is to find no reasonable grounds regarding discharge. It's been moved and seconded. Is there any discussion among commissioners? Seeing none. If you're in agreement with the no reasonable grounds proposed finding, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
No.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
No.
So the motion passes by a vote of 3-2, and the finding is no reasonable grounds. So there is 1 reasonable ground and 1 no reasonable grounds finding. The commission will let parties know, confirm that in writing, and we thank you all for participating in the hearing.
Pursuant to 1 MRF section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Is there a second?
Yes, second.
Well, it's been moved and seconded to go into executive session pursuant to FOIA. Any discussion among commissioners? If you're in favor of going into executive session, you will vote yes. Commissioner Ashby? Yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay, so now we begin what is always a surprisingly tense move into executive session to make sure that we are not somehow broadcasting while we are in it. All right, I'm gonna move people. Tom, you should get an invitation to move in there. Everybody else is here, so hold on. Hold on. I will join that. Everybody else who is still in the meeting, we will be going into closed session. The meeting will continue to be broadcast, but you should not be able to hear anything that we are saying. Hey, Kit, are you able to check? Yes. How you're the person Try that. Can you hear us now? Okay, so.
Yes, I can. There we go.
Tom, there's been a motion
Yeah.
by staff to litigate H220114 and not litigate H200410. There was no discussion. Do you have any discussion you would like to include?
No.
Okay. Then I am asking commissioners to vote on the motion to litigate, not litigate. Commissioner Ashby
Yes.
voted for, Commissioner David voted for, Commissioner O'Brien voted for, Commissioner Walker voted for. What is your vote, Commissioner Thomas? Commissioner Thomas.
For. Commissioner Tom. Commissioner Tom votes yes.
I'm just making up names now.
You ready?
Yes, ready.
I move that we approve the settlement agreement in H200340.
Is there a second?
Second.
Okay, it's been moved and seconded to approve the settlement of Tummings versus Russo. Is there any discussion among commissioners? Seeing none, if you agree with approving the settlement agreement of Tummings versus Russo, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay, I believe that's it. Nice job today, everybody. Thank you so much. We'll see you. Tom, before you go, do I have your authorization to sign your voucher? Yeah.
Oh, you do.
For attending?
Buddy.
Okay.
Thank you.
Thanks so